And this is October 17th, 2020. My name is Charles Stewart. I'm in Texas. And this is another in our series of conferences, which is designed to promote the ability of our common American people to access courts of law that actually follow due process of law in the United States of America. And since we seem to be the only one community group actually concerned about those technicalities of lawful procedure in the USA, we are referring to ourselves, at least for the time being, as the Supreme Court of Law for the United States of America. And we do invite people to bring cases before us, and we've actually got a few cases coming in here. But please, let's take a moment to humble ourselves and seek guidance and direction from the spiritual realm, the supreme forces of truth and justice in the universe, if I might. In the biblical Abrahamic tradition, true God, Yahweh, Jehovah, please send your Holy Spirit to guide and direct us, to help us discover the principles that make honorable spirit creatures, including we humans, interact together in honorable manners, to become knowledgeable about how to preserve peace and respect and empathy for each other, that we please keep us from becoming overly competitive. A little bit of competition may be good in a friendly spirit, but competition can get out of control and become intense. And at that point, the respect starts breaking down. So please keep us far from that. Help us to be humble and spiritual in everything that we do, seeking peace and justice for everyone around us and for ourselves also. And thank you for the example of your precious Son, Jesus Yeshua, in setting the grand example here 2,000 years ago. And in His precious name we pray these things. Amen.
Excuse me, Charles, before you get started, we've just been joined by a few. I think there have been 3 people that have joined us within the last couple of minutes. So wanted to say welcome, Janet. And also, most recently, I think that was Nancy that's joined us. Mm-hmm. Welcome, Nancy. And prior to Nancy joining us, there was one that joined that I am not aware of. Greetings. Would you like to introduce yourself?
Rich, California. Hello, everyone.
Greetings and welcome, Rich. Thank you. Charles, you've got the floor.
Thank you, Louis. Thank you, Rich, and welcome, Janet. I'm jealous. You've got your video on. I think I'll turn mine on, too. There we go. Okay, item number 2 on our agenda is promoting consensus on who is or who is not a qualified elector. If we don't get much feedback on this one, that's okay. But I wanted to set the tone for a lot of where the rubber meets the road in the common law community building that I visualize. It gets down to people that are compliant with the rules of the common law as articulated in the 7th Amendment, and those who do not. And at the grassroots level, that's kind of fuzzy. It's hard to tell people on the street whether or not they comply with rules of the common law. But there are people in positions of leadership in this movement that it's really easy to tell by their actions, by the manner in which they're leading others, whether or not they are complying with the rules of the common law. And for example, up there in Canada, our friends have a fellow that is probably the most significant player on the world chessboard that is advocating promoting so-called common law courts, but he's doing it wrong, and I think it's purposeful, and I am on the record as publicly challenging his status as a qualified elector because I think he's a deceiver. His name, he's been active in Canada, I think, and anyway, his name is Kevin Annett, and he's done some really good work in pointing out the satanic devil worshippers that rape children and then murder them in largely in Canada, but also touching in the States and all over the world, England, and so that's just one example of how we can progress. Because when new people come in and they're trying to sort things out, they can go to my list of people that I affirm that are qualified electors, and people that I'm indifferent about, I either don't know or else they're kind of goofy, but not bad enough to really object to. A lot of people in the middle category, and then there's a lot of people that are purposefully deceptive, and Kevin Annett is one of them, and there's others like Keith Livingway, and that's just a couple names off the top of my head. But we need to be gravitating towards each of us composing our own list of who we believe is honorable people, qualified electors, who major players that we're indifferent about. We can see some merit to, but we've got some problems with, and then people that we know are absolutely misleading the people. They're malicious, and those are the ones that each of us would want to certify as not being qualified electors. And maybe I'm wrong about some people I'm certifying as not being qualified electors, but I don't know until I compare notes with the rest of you, and vice versa. And thereunder, we should be able to arrive at consensus. If we're all righteous people in this community, we should be able to arrive at consensus about who's good people, who's kind of sitting on the fence still, and who's bad people. So I'd like to, I gave a couple of examples there. I'd like to ask if anybody would like to publicly affirm good people or that are qualified electors, or anybody that's really problematic that you've come across recently that you want to stand up and speak out and say that person's dangerous. He's no good. You might as well not waste your time with him. I'd publicly challenge his qualified elector status. So is there anybody that would like to make the record on that issue, either affirming or denying qualified elector status for anybody? I yield. Anybody? There's somebody that I've been sharing with Michael Zarzano in Florida there, Roy Potter. Roy Potter produces some really good YouTube videos. He's an ex-military fella. And I just realized he just put out a 58-minute video here within the last few days that where he's a serious biblical scholar. He comprehends the spiritual side of the battle real well. And he's pretty right-wing Republican. He's ex-military, but he's putting it all. He's standing up against Trump. That's what really delights me, because most people on the right-wing conservative side are either fence-sitting or on the bandwagon with Mr. Trump. But Roy Potter is fully up to speed. He knows that Mr. Trump has got problems. So that is really precious. And his entire mannerism, he circles himself. He quotes other people. Anyway, I'm dwelling too long on that. One more time. Anybody have any qualified electors they would like to affirm or deny? Then I'll go on to another item. Anybody? Hearing none. And by the way, web links in the invitation there to how David Scheid and I have created a rough list of the qualified electors. But I'd like to point out here to be the process for being recognized by our Supreme Court as a qualified elector. To my mind, this is very powerful. To my mind, this is more powerful than completing paper to take back your birth certificate, things like that, so that you're neutralizing the records in the evil empire. That is good process. I don't question that it's beneficial to go through those steps, but they seem quite burdensome, and I think filling out the oath of office of a qualified elector, and I expect that we should soon begin issuing identification documents. And I'm willing to do that. I'm willing to put my signature on documents affirming each of the people here. I do believe, everybody here, I'm willing to certify as a qualified elector. I know y'all well enough. I'll try to get documents, start working up documents like that. And that is evidence of identity that should be able to be presented to police officers on streets and things like that. And I do believe it's even more powerful than the standard method of escaping the 14th Amendment slave status, the straw man legal fiction that is overlaid to give color of legitimacy to the de facto judicial system treating us all like slaves. There are a number of ways of breaking out of that. But and similarly, the oath of office document for qualified elector, we've also got that for the town constable and the JLP precinct captain, which is the judicial officer. This is immense power at our fingertips, and I'm just one guy, or we'd have this up and flying a whole lot better by now. But anyway, comments, questions? I can go on. Asking for anybody? No, okay. Continuing on, we've got eventually, it's probably a bit premature right now, but we do have a link to one case that is probably going to become before us here, where Cynthia Moore in South Carolina is fighting against a foreclosure. And I'm helping her, and so we're laying the groundwork for a real court of law decision there, even though the bankers might just back off because of the paperwork that we've laid on them. We've done some real interesting things with negotiable instruments under commercial law there that's way more advanced than what a lot of gurus in that commercial realm are doing, I do believe. Anyway, and yeah, well, of course, we've got the other case with the treasonous conspiracy on the fraudulent coronavirus emergency. We'll talk about that in a moment. That's item 3. Anybody have any new items they'd like to have placed on the agenda?
Hi, it's Janet. I don't have anything new, but I just wanted to ask a question about what you were just speaking about.
Sure.
When you're talking about your administration, are you talking about just one state, or are you talking about the whole country? Like what we're doing is we're setting up each province as a state, or as a state. So Canada was 10 provinces and 2 territories, and because we don't have a constitution, we're looking at each of our provinces becoming a state. So when you're addressing everybody here, I'm uncertain. Like, is each person representing a different state? And because we were told to write a constitution, then place an administration, and then have a court set up. So your folks are probably already at that point where you have all of that. But when we're talking, are you talking about like a federal, like when you're looking at these cases, they're federally or they're per state? And have you guys already set up all your administrations as a republic? because we have not. We're trying to do that.
Okay, well, I appreciate the question, Janet.
Thank you.
I hope we don't have an echo there. Yes, once the judicial power becomes available and is properly functioning under common law, like what we're trying to do here, it's as you're surely aware, it's quite difficult. It's hard to find anybody that is holding assemblies that are reasonably posturing as following due process of law. Due process of law is a subset of common law tradition about how courts should operate, and I frequently use the word organic law, and I'm happy to see that that has caught on, and a number of people reference those type of terms. And you're talking about structure that a lot of the people that posture as scholars in these areas, I don't think they really comprehend how organic law works and how judicial process under common law works, because and you can see hints of this in the Seventh and the Sixth Amendment. The jurisdiction, the formalities of establishing communities of people are less important than organizing a court to administer judgments in response to a complaint before the court, because by the very bringing forth of the complaint before some community of people that is at least posturing as a court, at that point, jurisdiction is established for the court, and it can be national, planetary, state level, province level, right on down to your county and precinct level. These are all capable of being courts of law. And if we had 12 people from Canada on here, we could convert to a court of law for Canada if we wanted to. So we're fluid here. It's not as rigid and statutory as what you and a lot of people on the state side here are presuming. For like the National Assembly group that Destry and Roger run, and the Beacon 37 group. This is part of why I get frustrated. I tune into each of those groups once in a while because there's a lot of good people there, and they are doing some good stuff. But they're caught up in the statutory. We got to have so many numbers here, and we got to have so many numbers there, and so many numbers there before we can start standing up and speaking out and defending our rights. No. That's all wrong. You can stand up and start speaking out and defending your rights now. Anytime there's a wrong, you've got the right to seek justice in response to it, and you've got the right to organize with anybody that agrees that you're not totally insane. You've got the right to build communities of people to get justice for you in response to the particular complaint that you're bringing before the public due process of law court. So I hope that kind of answers your question there, Janet. I yield. All right. Thank you, Janet.
This is David, if I may.
David, please.
In Michigan. Well, I totally concur with you. I am putting that into practice myself as we speak. But I wanted to see if since you've got a recording going here, and other people may listen to this later on, if you might explain, Charles, how, despite what our intentions are, how to deal with the criminals of domestic terrorists that I refer to as that are calling themselves government, that are would like to use the term simulating a legal process and using that as a criminal charge against anybody who is what they might consider subverting their system. I yield.
Michael from Florida there has been concerned about that simulating legal process charge also. And that and a few other similar things like paper terrorism accusations and stuff like that. These are legitimate concerns because numerous good people have ended up in jail because of precisely these kind of charges. And this dovetails to another issue that I think it's good to address at this point. A number of you, Terry from Hawaii, noticed that in my current email invitations, I've been putting on the copy line, U.S. DOJ and the President and the Vice President. And see, the two issues relate because by sending them copies of the email, at that point, it's clear that we're inviting everybody to come in, including them, to come in and state any concerns about what we're doing. See, if we embrace the light publicly in what we're doing, then the charge of simulating legal process, to my mind, that charge, if we had a conscience-bound jury, and that was really brought against us, my first gut reaction would be to counter-complain against them. I'm fond of doing counter-complaints. I've got a track record of doing counter-complaints in response to traffic issues and stuff like that are being brought against me or people I'm working with. And so I think they've got a computer data file on me that shows that unless they're just going to straight railroad me off into jail and not give me any due process of law whatsoever, I'm going to make a stink in front of a jury, and I'm going to counter-accuse them of being the paper terrorists and simulating the legal process, because they don't follow due process of law. We're the ones trying to follow due process of law. They don't allow the jury to use their conscience. That is how real law works. Real law allows the jury to use their conscience to do what's right before God. They're not supposed to be a bunch of damn robots that are just doing what the prosecutors tells them to do. It gives me a little bit of self-confidence that I know I've got slam-dunk arguments burned into my brain cells to beat that kind of a charge amongst anybody. If there's anybody in the room that even postures as being a reasonable person, I think I can embarrass the de factos if they're trying to bring those kind of simulating legal process charges against me. But I do comprehend that a lot of other people that aren't quite so confident in these areas as me may be a little bit apprehensive about being charged with simulating legal process or terrorism, paper terrorism, and stuff like that. So I understand it, I comprehend it, but to my mind, it's not a serious danger for me. And how I'm interacting with the community, which may be more of your focus here, David, the group here. That's why on the next item on the agenda, the coronavirus militarism complaint, with the exception of Abraham, that's actually bringing the complaint, I'm the jury foreman and chief judicial officer of the Supreme Court of Law here. So if they're going to come after anybody, it'll be me or perhaps other courageous men like Abraham. You know, there's very few that are as front line on this spiritual battlefield here, legal battlefield, however you want to term it, as me. And so I'll be the first one to go down, and I don't think I'm going to go down. But and this gets to Sun Tzu, tactics for warfare, universal tactics for warfare. The leader should be he should be the point man. He should be the first one to go down in a conflict, and I'm willing to serve that role because I'm kind of, the one calling these conferences and putting them together and everything, and I'm pushing. I composed Abraham's coronavirus verdict and presented it to him, and Abraham read it and he said, "Yeah, that looks good to me." And so Abraham is doing great. I see if there's lots of us with courage, then the bad guys are really in trouble, and that's why we're looking for the jury verdict. 12 people with courage. That will really, really mess with their evil empire agenda. Nobody does stuff like this. It's clear in the 7th Amendment that this is where the brass ring is. This is where the real grassroots empowerment's at, but nobody does it because we're all intimidated and trained in the public school system to be good little slaves. And don't rock the boat, and don't get accused of simulating legal process or paper terrorism, or boy oh boy, they'll railroad you off into jail without a fair trial. So anyway, there's a lot there. You're touching on excellent issues, David.
Well, if
I hope I answered your question. If not, clarify.
Yes, thank you. Well, I wanted to take it one little step further because I think that there's probably more than a few on the line here that know and have heard of something called a motion for limine, L-I-M-I-N-I-N-E. I happen to have it up on Wikipedia right now, and basically, it's a motion to exclude certain testimony, which is supposed to be in criminal cases to protect the defendant. But I've seen it used a lot in civil cases. Cliff knows what I'm talking about, and it basically is a means that you might want to protect yourself against, or all of us, or at least think about a plan to move forward with when this thing is thrown into a court by the prosecutor to try to exclude testimony coming from somebody like yourself if you're trying to step in on somebody else's case. So think about that. And I've got the Wikipedia up if anybody wants to have me read it, but I think I summarized it pretty well. But I believe that it's something that we should consider as one of the dirty tools that they would likely use to bar, your involvement in a case that they have against another defendant. I yield.
Thank you, David. That motion in limine thing was one of the main tools that was used against the Colorado 9. The Larry Goodman case that I was involved with, they were using that routinely on Larry Goodman. And I know they do use it frequently. And in their courts that they control, that is a problem. This is part of the reason that I'm so fanatical about us forming our own courts like what we're doing here, because if we wrap it all up, put a jury verdict on it after reviewing all the evidence without any motions of limine obscuring anything, then our jury verdict probably supersedes and trumps anything that they can do. And that's a whole different argument that's way more powerful than merely procedural things about whether or not in their de facto courts the motion in limine is appropriate or not appropriate. See, when you're arguing before a municipal government franchise judge, that a motion in limine is not part of due process of law, which it's not, but and it's unjustified to divert from due process of law in this specific case, like the prosecutor's going to be arguing that it is justified. You'll try to be arguing that it's not justified, it's not reasonable, but guess what? The judicial officer in charge is inherently prejudiced against you because he's an employee of the Roman Empire slave trader jurisdiction, municipal jurisdiction.
And if I may, Charles, excuse me one moment. We've been joined by someone about 3 minutes ago. Greetings. If you'd like to introduce yourself. It appears that I've recognized.
Colorado.
Okay. Thought that was Daryl. I thought that email address looked familiar. Greetings, Daryl. Welcome. Charles, you've got the floor.
Yeah.
Thank you, Louis. Good to hear you, Daryl. Yes, thank you. I think I kind of responded to David Scheid pretty well there. David, did that cover everything?
Yes, indeedy. Thank you.
All right. Does anybody have any comments or questions on what I was just saying there? Hearing none. Let us proceed on to the agenda item number 3. This is probably the major step that we're moving forward with. This is the criminal complaint that I mentioned a little bit ago. I've brought before Abraham, and I composed it basically. Abraham helped with fine-tuning it, Abraham has courageously agreed to bring it before our Supreme Court of Law. At this point, I can assume the position of the chief judicial officer and jury foreman that's trying to bring 12 people to unanimous agreement that the complaint that Abraham is bringing before our court is legitimate, lawful, and justified. And so we're taking baby steps, and it will be good when we can finally get 12 people to agree that I've composed 2 documents. I've not only composed the basic complaint for Abraham that he's agreed to bring before the court, I've also composed a rough draft model jury verdict that addresses the issues related to this coronavirus emergency declaration that is shutting down the economy and everything. And once we get 12 signatures on a document similar to what I've composed there, I expect that with trying to build consensus amongst 12 people, there's going to be some editorial changes that will need to be made. This is just a rough draft to start working from, and so the people with courage that are really ready to stand up and speak out against this evil that's coming against us through these fraudulent coronavirus emergency declarations, these people will be will have input process in editing the final jury verdict document. And so please, people, and I've done some recent updates. I've initially we were avoiding adding President Trump as a co-defendant in this complaint because we were hoping that things would turn to the point where we could actually view him as being just misguided or bullied or something. But as we've been talking about it in recent conferences more, we've kind of decided that Mr. Trump is the chief authority of the entire executive machinery of government here, and we wouldn't be suffering nearly as badly under this coronavirus fraud if Mr. Trump was actually standing up and speaking out. So anyway, we've recently added Mr. Trump to the complaint and the model jury verdict there, and And so it's really ready to go, and to, at this point I would really ask that people look at both the complaint and especially the jury verdict, because that's where the rubber's meeting the road for the qualified electors that are going to be willing to sign on to this and to stand up and speak out against this military police state that's coming at us. And please notify us, especially myself, if you've come to the point where you've read the document and you're willing to stand up and speak out as a qualified elector juror in affirming that our first model here, we're not addressing individual people like Mr. Trump or Mr. Barr or the other players. We're just saying that we got the right to resist with forcible vaccines and a few other general issues like that are low conflict type of issues. And we'll probably do jury verdicts different that are supplemental at a later stage. So this one's a really tame jury verdict just to get started here. But at that point, I'd like to yield. I imagine there's at least a little bit of commentary or questions here. I'll yield for the group. Any comments or questions? I yield. Anyone?
I'll go ahead. This is David.
Yeah, David.
Charles, as you know, I'm disabled, and I'm battling some of my own personal battles here. I've been on attack for quite some time, the recipient of attacks, and my time has been filled with my own self-defense, you might say, and so I just wanted to let you know that I have been frequently having to ask people to provide me with disability accommodations in order to get access to certain things, and so I will probably ask the same thing of this court, this forum, to get some assistance in it's very time-consuming for me to be able to do this, be on here, and try to download documents and read them and comprehend them and deal with other people's submissions when I've got my own, and they still are unaddressed. So I have to kind of address those with others all on my own. So I just wanted to say all that to preface the fact that I need some, I might be able to gain total access to comprehending those documents that you just referred to as submitted by somebody else. And as I get familiar with that, I might be able to participate in any type of a voting or a decision making, a verdict or anything like that as one of the sovereign people. But if I may have to beg out of it if I don't feel like I've had quite full access to the information. I yield.
Sure. Thank you, David. If I might respond to that, I'm doing the strategy that I'm pursuing here is quite a bit more, I guess, for lack of a better word, liberal than what the normal courts use in forming juries. The older common law, prior to the Norman Conquest, and even in times afterwards, juries were assembled spontaneously from the members of the community, and when one party or the other finally got 12 to be in unanimous agreement, then that was the conclusion of the court's judgment right there. It's a threshold number, and he wouldn't be able to get 12 people to unanimously agree with him, whether he's the plaintiff or the defendant, unless some of those people were not qualified electors in the community, and when you comprehend that only qualified electors in the community get to vote, and they got to maintain their qualified elector status, and if they vote fraudulently, they're going to lose their qualified elector status. See, at that point, you can assemble your jury in a much less regimental manner, a much more organic, grassroots, consensus-building manner. So what we're doing here is presenting the model jury verdict document. And David, when you're not doing nothing, well, I know you're doing stuff all the time, but and this applies to everybody. Just try to become familiar with the jury verdict document, maybe print it out and get a red marking pen and say, well, scratch out certain portions. I don't like that, I don't like that, I don't like that, I like this, I like this, I like this. And then next time we come into conference, you can make suggested changes. And other people can make suggested changes. And as we start working towards building consensus on what changes are needed and what changes are not needed, we're all sincere. I like to believe everybody here has qualified elector status, has good, honorable intent, and if that's true, then we should all be able to respond with similar conclusions about what is in the interests of justice in response to the main complaint that Abraham is bringing here about this militarism coming to us. So, yeah, I covered a lot there. I should probably yield for comments or questions. David, anybody?
Thank you.
Sure, David. So does anybody else have any questions or comments about how they might interact with the coronavirus jury verdict here, or how it's designed to function, or even if you're not even considering doing it yourself? Do you think this whole idea is stark raving insane and it needs to be shut down or something? If you do, please let me know. If you think I'm simulating legal process by bamboozling Abraham into sign on to this or anything like that, please raise your hand and let us know. It looks like Janet would like to say something. Janet?
And Janet, if I may, Daryl, you've got some background. We're picking up some background noise from your line, so if you could please either utilize *6 to mute and *6 again to unmute if you'd like to comment, or just mute on your phone. Thank you.
Janet?
Yes, we're going through kind of a process in Canada, and I don't know if it helps you or not, but we have made the differentiation between the corporate private court and the common law public court, which up until now, all it's ever been is corporate court. And we, the people, did not understand that. The court itself is, if you're accessing it, unless you access it with your own jurisdiction, I'm probably a kindergarten compared to what you understand, but we have been shown that we need to make sure we don't go under that corporate language or paperwork. We go under the law of the land, and so those courthouses belong to the public, and they have been using them for their private corporation, and they treat us like a corporation because of our identification. They've made us all corporations. So what we have is a fellow named Christopher James, who is showing, put in our paperwork, common law paperwork. We have nothing to do with the corporate system, and therefore nobody should be coming into the courts except the people. And that means no lawyers are coming in, there's no lawyer terminology, there's none of that. And it's all about the people. We don't even use a judge. We're using like maybe a panel of people that may understand the law, such as a criminologist or somebody of that, but none of those people are allowed in the common law courts. Now, getting in there right now is the struggle. He's gone back and forth 4 times with paperwork saying, what are you people, like the Attorney General and lawyers, trying to come into these courts? and he is telling them, you are not to come into our court. This is the court for the people. It is not for corporation. And so when I'm looking at your paperwork, I'm not sure. Anyway, I'll leave it at that, but that's kind of the process we're going through, is we're actually differentiating the type of court. Those people cannot be allowed in, and the register has to address that. They have to keep those people out. That's their job. So I yield.
Thank you, Janet. I have noted the work of Christopher James. He's got a number of platforms. I think he's got a YouTube channel and a web page. I think his YouTube channel or web page goes under the title "A Warrior Calls." Is that correct, Janet? Okay, good. Yeah, I'm from an arm's length. I'm admiring the fellow. What he's talking about is taking back the courts. That's really a rubber meets the road issue that is really important, and it takes courage, and he's obviously got a lot of courage and insight into what the nature of the problem is and what the solution is. I do like to think that his strategy could be improved on pretty significantly. I'd love to have opportunity to talk to him. I've seen that he does his own conferences, but they're not really conferences. It's just him talking and people in the chat room maybe making comments or something. I wish he would come here and engage in open discussion, because that's where we really get the cross-pollinization of ideas, and we become stronger collectively when we share. When one guru grabs the microphone and just does all the preaching like he's the big guru, then other people can't help him improve his game, and he's less capable of explaining details in real-time discussion with people that are having troubles comprehending what he's saying. If you've got any influence with that Christopher James fella, please invite him here, or give him my number, or ask him to invite me to be a special guest on his show or something. Because I'd really like to talk shop with him and to try to improve the game strategy for everybody. But when he's got all those defense walls around him, and so anyway, I should yield here, I guess. I hope I commented clearly there.
Yes, thank you. He's actually trying to teach very simply what he's bringing forth for the people. So I think that's why he just talks on, because it's like we're learning a new language about law, and a lot of us, it has to be very simple for us. But for you, you would be able to talk to him on maybe a different level. But for a lot of us, we have to just understand the difference between laws of the land and the admiralty law. You know, we're starting right from kindergarten, as it were. But also the courthouse itself, and the environment and the paperwork is all, and the identification is all part and parcel. So each of us, if we're going to participate in jury, we have to see and know what's going on so that we don't get corrupted by the corporate. They keep trying to sneak in to the common law process. And so he's showing us how to do that. But I can just put an email to him. I don't know if he'll respond to it, but he does have a chat. And I believe he has a contact. So I will do that if you wish. If I have your email, it's on one of our notices here, then I could do that, because he is reaching out to people that have court cases, and there are people all over the world. And one of them right now is our Norman Travesey, who's suing Justin Trudeau, our Prime Minister. So he's taking on some pretty big ones, but he's also taking on, like, everyday, you know, people having their property seized by our service departments and so on. I yield. But I would be glad to do that. Thank you for your response.
Thank you. Comments or questions from others here? Anybody? Hearing none. I think we're fairly well covered with our coronavirus counter complaint here. Yeah, I think we covered the basis there pretty good, and that's probably the biggest. That's the most important thing before our court and community right now. But it'll be here for a while, and please, I just would like to encourage everybody to review the two documents, especially the jury verdict, and contemplate whether or not you can actually participate in signing on as a juror to something like this. And even if you can't sign on as a juror, if you see something that we're doing wrong that's going to get us in trouble or that's wimping it out, please let us know. We love constructive criticism, even from people that aren't willing to sign on but who have good hearts. So we're open to constructive criticism if we're doing something wrong. But continuing on to item 4, Michael Zarzano, maybe I can presume on you a little bit to speak on behalf of a suggestion that we've pretty much already agreed on, at least in private discussions, myself and Michael and Abraham and others have talked about this too, and it's about public outreach for the kind of work that we're doing here, where we're talking about really serious grassroots empowerment to our common people. This is so revolutionary, empowering to our grassroots common people that Michael and a number of the rest of us have been strongly advocating that we need to build our numbers, and Michael here was specifically focused on hoping to put it on an agenda item here, as we've done item number 4 here, to talk about what we can do to build a social media campaign to try to build the numbers to get people enthused about what we're talking about here. Michael, would you care to elaborate a little bit on the proposition that we've incorporated here into agenda item 4, Michael?
Sure, I would. Thank you, Charles. It's really very simple. Unless we have other people participating with us, it's going to be very difficult to achieve anything and be heard. And it's, I think, a necessity, an absolute necessity, that we begin an outreach effort, each one of us, through our social media outlets, platforms, to seek out people in our area or our state that feel as we do in regard to the government and the times that we live. We're in emergency status.
If I may, Michael, could you speak up a little bit?
Is this better? Is this better?
No, not much. I don't know what's going on, but I could hear everybody else pretty clearly, but you're very faint.
All right, well, I'm listening on a headset, a Bluetooth headset. I'll disconnect.
For some reason, you're coming across very distant, Michael. You're barely registering in the green. 1, 2
better?
buttons. Much. There we go.
Okay. I eliminated the headset. All right, so is anything needing repeating, or did everybody hear what I said?
I think we got the basics there, Michael. You might retest the high points. Go ahead.
Yeah, I don't really know that there's much more to say. It's quite self-evident that we're going to need other people participating with us, and in order to reach those people, we've got to figure out a way to get them to hear us and to join us. And this is actually very elementary. We can't do anything without others, and I think it's very important. It seems that all the groups that are seeking remedy in one fashion or another, have the same problem, and that is, getting people involved. So I think it demands attention. It demands, a fix. We've got to figure out how to change this problem. So I'd like to hear comments. Otherwise, unless we succeed at getting other people, we're not going to go anywhere. I yield.
If I may, this is
name and state, please.
David in Michigan.
David, yes, you got the floor.
I just real quickly with Mike's comment of needing. To me, I kind of think that if I don't mean blasphemy here or anything, but God has given each one of us all we need to do what we need to do, and in my view, if you give somebody some money, and they can adopt the view that no matter how much they get, it never seems to be enough. And so I'm kind of the view that regardless of, and I think Charles would probably share that view, is that we start with what we got right now, because right now we got, if there's two people that can pray together, and that's supposed to be sufficient according to the Bible, then I think we have enough to go with in good faith to move forward, and I don't. So I yield.
May I respond?
Michael, yes.
Yeah, there's no doubt we need to start, and we've already done that. That's a given. That's accepted. I have no problem with that, and I don't think anyone else does either. But in any organization, whether it be a benevolent, a for-profit, any type of organization, you have to reach out in order to grow the organization, and you have to have a strategy to do so. And in this particular effort, it is vital that we have people, numbers of people involved, quality people. So we need to begin a fishing expedition, if you will, and I just think this is very elementary. It's not rocket science. Common sense demands this, and it's just part of the program. It's part of the effort. I yield.
Further comments or questions? I've got some ideas of my own there, but I'll yield if somebody else would like to say anything.
I yield.
All right. Thank you, Michael. I guess that'll. I like David's choice of words here. Of course, everything Michael says is absolutely true. We do need the numbers. We do need a media outreach campaign. But I think David is a little bit more harmonious with me in thinking that it is kind of like the saying, if you build a better mousetrap, the people will come, something like that, that when we start producing good work product like our coronavirus jury verdict, once we get 12 people willing to sign on to that as being true, and then we just start distributing it publicly and declaring that our people, the people of the United States of America, that the jury is reflecting the conscience of the people. The people are speaking here through our jury. That's what it's intended to do. Once these radical game-changing ideas start being put in front of news media, the U.S. de facto municipal Supreme Court, the U.S. de facto municipal president, the House of Representatives, the Senate. Once we start pushing these things to individual senators and representatives and at the head of FEMA, the head of Homeland Security, once we start pushing these things and start telling people that they need to back off in their military police state agenda there and there and there, then it's going to get notoriety. People are going to spontaneously begin talking about who are these group of crazies that think that they've got the right to tell the U.S. government that they can't do anything. And it'll be a point of discussion. And there's a lot of people that are really upset about this evil empire agenda of militarism that's coming down the pike, and they're going to be rooting for us, and they'll be spreading it around because it's in their interest, because they see the same danger that we see. And they're under, certainly the idea of focusing on media campaigns to bring these issues out and to make them more popularly comprehended. That is an essential ingredient of the overall strategy to bring about the changes we seek. Yes, no doubt. But I think our optimal strategy with our limited resources here is to stay focused on the ball, the moving ball. One of the principles of common law is you need a real case from a real natural person before the court. You can't do legal fictions and things, and part of that reason is because it really metaphysically empowers the court. The complaining party has a vested interest in moving the court forward in response to his complaint, and so when we capitalize on the motion that's already through the complaints of Abraham and the rest of us that are focusing on this coronavirus jury verdict, or the other cases like the foreclosure case, we've got real-world complaints that when we're asking people to get involved, it's because we've got injustices that we're trying to remedy through this case and this case and this case. And they can see exactly what they're signing on to. They know it in a digitized, detailed format because the documents and everything are all there, spelling out the grounds for the complaints in very detailed manners. When the minor problem that I have with generally talking about trying to mount a media campaign is we'll be talking probably, as I visualize it anyway, maybe you can correct me if I'm wrong, Michael, maybe you've got a better way of doing it, but we'll generally be talking about general empowerment and things like this as reasons why people should sign up on our webpage and become part of the group and start attending the conferences. When we're doing that, we're talking in general terms with the general benefit to them that is kind of theoretical. And I don't think they will feel the same type of real-time necessity to begin physically participating in bringing justice for our common people as they do when we're focusing on specific complaints here. So I guess to boil all down my comments here, I would only be apprehensive that perhaps a media campaign may take time and energy away from focusing on our complaints and moving forward with what we've already got going. I'm 99% sure you didn't intend it that way, Michael. But anyway, maybe I should yield there and ask you to comment and maybe clarify a bit. I yield.
No, I just think that it's an integral part of the entire operation. You can't divide the two. You can't divide, doing the filings and the complaints from, outreach. I think they're inseparable. They're inseparable, and they need to simultaneously, be achieved.
All right.
In order to get people to, use the new mousetrap, they've got to know about the new mousetrap, and along with the notoriety, you must have the knowledge of the mousetrap to achieve the notoriety. So I don't see them as being, two different operations. They're the same, and we must do both. Because I look at the National Assembly, if I may. I just thought this here. If I may, the National Assembly, how many years have they been having their Thursday night call? And they just keep spinning their wheels. They at one time they had, far more than they do now on the call. They've lost numbers. And it's because they're just spinning their wheels, talking about the symptoms. And they're not the only ones. There must be an effort to gain numbers. Otherwise, you're putting the cart before the horse. I yield.
Thank you, Michael. I'm glad we're on the same page there. Comments or questions from anybody else here?
Well, this is David. I just wanted to chime in and say, yes, I totally agree with Michael as well. And media was my background and still is. So I'm totally with you there. I yield.
Thank you, David. Anybody else? Comments, questions? Well, I think we should go ahead and move on to our agenda item 5 then, as Lewis has so effectively pulled up on the screen for us. Organizing our qualified electors in our USA under the 12 superstates model. And we've got a map and organic hierarchies. Yes, there's the map. Lewis is nicely presenting that. The inherent necessities of government is under American constitutional law generally, one of the most highly prioritized issues is administration of justice, because if you don't have justice, you can't have peace. There was a movie where Charlton Heston said a line like that: "You can't have peace without justice." And I do believe that's true. And according to common law tradition, which is the most advanced body of law on the planet, I'm willing to make that statement. Common law is the most advanced body of law on the statement. There's people who like commercial law, like my friend Hartford Van Dyke, and there's people that like administrative process and arbitration and admiralty and maritime and all kinds of other stuff. But I do believe common law is the most advanced system of law on the planet because it not only includes due process of law, and I like to think of due process of law as a subset in due process of law as referred to in the Fifth Amendment. That's a subset of the larger body referred to in the Seventh Amendment of the rules of the common law, because there are numerical requirements in general common law tradition, like the accompanying web link about organic hierarchies. The big game changer between common law and all the other systems is that it's based upon consensus as reflected by the well-known requirement of juries that are really lawful juries to have unanimous verdicts. Everybody knows that the jury is supposed to have a unanimous verdict. Now, there have been a lot of statutory enactments saying that, they don't got to be unanimous. Well, when they do that, they're creating a different look-alike type of jury. It's not a real lawful jury. It's not a real court of law. These are tried and true principles for bringing real justice. When you have to have unanimity amongst the 12 that are making the decision in the court process, that is a protection for people that might be wronged by the court process. And I've conducted a number of jury trials myself, and I've participated in de facto jury trials, and I know for a fact that people can be brought to unanimous agreements in response to complaints before the court in fairly quick and efficient manners. All you got to have is good, healthy, open discussion and humble people willing to recognize other people's points of view and willing to consider important issues from other people's points of view. When you've got that sort of open-minded, empathetic type of discussion, then it's pretty easy to bring about the consensus, the unanimity of the 12 stakeholders in the judicial process that is coming forth under common law jurisdiction. And the only reason that is a profound game-changing proposition when we insist on 12 people unanimously agreeing before anybody goes to jail or gets deprived of their property. That's a profound protection. And to abandon it, to go to some other type of a process that, oh, gee whiz, we just get a black-robed tyrant from the municipal jurisdiction, finally being pressured by all the affidavits that we've filled out to grant us a judgment in our favor. Well, okay, I'm glad you finally bamboozled the corrupted judicial officer into respecting your rights. That's a good thing. But in terms of long-term salvation of the nation, our American people, we need something different. We need something bigger, like the rules of the common law clearly indicate. Thank you for bringing up that document, Louis. This is how and why organic grassroots community building is so important. This is the Torah law model, straight out of Exodus 18. We build the smaller communities of the tens and the 50s and the hundreds and the thousands. We're kind of glossing over the 50s for a moment, for the time being, as we're getting started here, because that's kind of an oddball thing that gets into metaphysical issues. But generally, the lower levels of hierarchies, the bottom 3 levels of the hierarchy, are multiples of tens. 10 households make a township. 10 qualified electors from each of those heads of household make a township. 10 townships make a precinct with 100 court. That's where the supreme judicial power resides, is in that 100 court. The supreme executive power is down at the township level, in the town constable. That's the peace officer. And 10 precincts, 100 courts, are the model based on Exodus 18 for a traditional common law county. The common law tradition carried on the biblical Torah law tradition, with this whole hierarchy building on itself and empowered by the grassroots, by the common people. So there's profound empowerment here, and yes.
If I may.
This kind of touches on the next item. I should yield. Yes, I think I hear somebody. I yield.
This is David in Michigan. I just wanted to let everybody here know that after reading this document that's up on the screen right now, that I did spend a couple of weeks of my own personal research looking into what Charles has propagated out here, and I was able to confirm and other documents that the truth of what he's talking about, and I've been able to write some things of my own, which I have not published yet, other than what I've given to Charles, and I yield. I just want to reaffirm that Charles does know his stuff. I yield.
Thank you, David. Words like that are worth more than gold to me. I do appreciate it. Comments or questions from anybody else? Hearing none. This relates to, I believe, agenda item 6, which is starting our townships and building our self-governing communities, and that the building the self-governing communities is also related to agenda item 7. So I think for purposes here, I should point out the connection. Agenda item 7 is actually the first in a series of 5 documents that I've got in a directory on the web page, as you can see in the web links there. Treason USA is the main directory, and the 2 web links in agenda item 7 are generally ordered there as documents number 1 and number 2, and then 2 of the documents in agenda item 6 are documents 3 and 4. And the reasoning behind the ordering of those in the same directory like that is because document number 1 is the constructive notice of treason document. See, we've got like probably, well, the numbers are getting better now, but probably at the modern time, maybe 75% of the population of the USA is in Canada. I don't know about Canada. Is walking around thinking that, well, this is how constitutional law works in the USA, and everything's going to be okay, and there's no really big, serious, nasty conspiracies or anything in the world, and we can just continue going along the way we're going, and everything will kind of take care of itself. We've got enough people concerned about issues of government and responsible positions of power that they'll take care of all of that, and I don't need to worry about it. That's how approximately, I would guess, 75% of the nation right now is thinking. They're not plugged in. And this includes probably 50% of the public servants that are out there. Maybe more than 75%. The public servants are really under a lot of pressure to just go along to get along. They got careers, they got college educations that they've invested in this reality. And see, so that gets to document number 1 under agenda item 7, constructive notice of treason. The entire Roman Empire model of government that was created by our state and national constitution documents, it created municipal civil models of government. Its law dictionaries, reputable law dictionaries, clearly show that civil municipal government is opposed to natural law, and it's opposed to common law. Our real rights, our system of higher law, comes from common law, as articulated in the 7th Amendment. What we've got with municipal civil law is a system of law that was engineered from early Constitution documents that has been purposefully, subversively engineered because it's intended to take energy away from the ability of the people to responsibly self-govern under traditional common law. Those are slave trader documents. And this is why document number 1 under agenda item 7 is constructive notice of treason. This is the game changer. A lot of people are talking about, oh, gee, we'll get arrested, we'll be charged with simulating legal process and simulating and doing paper terrorism and stuff like that. Those are legitimate concerns. I don't want to take away from that. But when we put paperwork like this constructive notice of treason document in front of people, and a second link document, number 2, the citations document showing how all of the common law rights that were guaranteed in that Constitution are slowly and steadily being eroded to where we're not going to end up as anything more than slaves here. The 2 documents, to present these to public servants at the local level or the national level or the state level, any level you want, it lays a foundation. It lays a paperwork foundation. And in the main constructive notice of treason document, it says therein, in numerous areas, it ends with it, please notify us within 30 days if you have any objection to the conclusions or any other issues proposed in this document. Thank you. Have a nice day. And so when 30 days passes after they've been given this constructive notice of treason document, and they haven't said anything, and then they come and try to prosecute you or me or anybody else for simulating legal process, we are in the real powerful position to say, wait just a second. Didn't you fail to respond to the documents I gave you 3 months ago? Didn't you forget to didn't you fail to respond to that? Didn't I point out didn't that document point out that you are not administering justice properly? That is in fact you and your whole Roman Empire municipal court system that is actually simulating legal process when real legal lawful process, due process of law, is exactly what we're doing. You're the ones that are doing the smoke and mirrors, not us. See, we're in the groove. We're at that point where our ability to argue these principles is an argument that they don't want to partake in, because they know the law probably better than we do. Leroy Schweitzer, Montana Freeman, he said that the de factos know the Bible and the Bible law better than we do. Okay, because that's what they're working around. There have traditionally been people talking about a little bit of Bible law here and a little bit of Bible law there, and that is always causing them problems. So they got to know how to create legal fiction arguments to bamboozle weak-minded people. And it's been working for a long time. They've been getting a lot of mileage out of it. But when we start presenting to the de factos documents like these, then that's a game changer. They got no more wiggle room. The arguments are all presented in the documents. All you got to do is refer to page such and so. We said this. The different page such and so. We said that. You didn't respond to any of these issues. That's the default. You haven't responded, and now you're arresting me for simulating legal process. This is a malicious prosecution. You should be in jail, not me. This gives us so much empowerment, and I'll break here in a moment. But this, coupled with Agenda Item 6, Items 3 and 4, the third and fourth item in the series under the USA Treason directory there, that talks about building our self-governing communities. And this is what this court's about, and this is what all of our precinct level and township level and county level empowerment structure plans is doing, the organic hierarchies document that Lewis had up there. This is what it's all about, is building our self-governing communities. When these documents talking about our rights to build our self-governing communities is in supplement with the treason document, that's catching them in the crossfire. We're showing them how corrupted their system is, and we're pointing to them that we've got the constitutional right to form responsibly self-governing communities that actually follow due process of law. At that point, we've got them in a crossfire. They've got no wiggle room. There is no logical, reasonable argument that they can make against when they receive both of these documents. In essence, these documents essentially amount to their duty to step down from their municipal office and to join with us, if they are so inclined, in helping establish responsibly self-governing and common law compliant communities. So I should probably take a break there and allow for comments or questions. But yeah, go ahead. I yield.
I apologize to everybody for speaking up so much here tonight, but it seems that it's appropriate to, at this point, to let everybody know that I did spend at least 2 years, probably closer to 3 years, in writing what I call an amicus and treatise that was over 300 pages, fully supported with public documents, and including Congress and everything else, giving a history of the United States from its inception up to where we are now, that supports what Charles has asserted in the treason, the allegation of treason, and so it is well supported. It's in public records. I've been able to make some sense about it and put it all together in a little over 300 pages, and I yield. It's also unpublished, but because I'm kind of holding on to it, waiting for the right time, because I know that most of America doesn't read. They wouldn't even read 100 pages, much less 300. I yield.
If I may.
Michael, yes.
Yeah, I don't mind your frequent additions, David, to this conference call tonight. It seems like no one else except the three of us is talking. How many are on the call right now, if I may ask?
I don't see how to...
I see 11 attendees here.
11? Okay, that sounds about right, yeah.
11, and we have 3 participants out of 11. I'm just bewildered at why no one else is participating. I yield.
Well, maybe I'm not singing and dancing flowery and energetically enough.
I would beg to differ. I think you're doing a fine job, and so
well, and if I may, I know that Cliff is on the line here. Cliff is not shy for words either, so just don't get him started. So and so it's not like there's anything to hide from here. Cliff's all out there, believe me. I yield.
All right.
Yes, Charles Cliff.
Yeah.
Yes, sir. I just wanted to let David know I'm on the line. Now, don't get me started.
All right. Glad you're here, Cliff. I can comprehend. I thank you, Michael, for sprinkling a little bit of friendly pressure on our friends here to try to jump in and help carry the burden of keeping the discussion energized and healthy here. That's a good thing. Thank you. But I'd like to try to encourage. I do more sticks than carrots, or more carrots than sticks. Anyway, and I'm not referring to what you said there as sticks, Michael, but that I think it's worthy of evidence or emphasis the four documents that we're referring to here: the constructive notice of treason document, and the Notice of Formation of Responsibly Self-Governing Communities document, like Lewis says on the page here. Each of those has a secondary document. See, I wanted to keep them all fairly short, and I think they're all about 15 to 18 pages, all four of them.
But if I may I interject?
Sure.
I don't mean to be rude, and I apologize if I come across that way, but this has been the case the entire conference call. It's not just this particular subject. There hasn't been hardly any participation by many of the others, and it's just very troubling. We are in an unprecedented time. We are in historic, tyrannical times, and it's very dangerous what we're facing. And I find it very bewildering and troubling, to say the least, as to why more aren't participating with their mouth and their voice and their mind. It's very troubling. I yield.
Thank you, Michael. I do have an idea about how to perhaps adjust our agenda a little bit to perhaps address that issue. Lewis, could you bring back the constructive notice of treason document there? Michael, you've got a web page devoted to emergencies, I believe, that's related to your Charlotte County Congress or something like that. This seems very similar to the constructive notice of treason document. Maybe we should take a moment here to explain the details of not only my constructive notice of treason document, but your declarations of emergencies document. See, this my thought here is that when we realize the nature of the emergency situations that are coming at us, that is the bouncing ball that people need to focus on, and perhaps we can, by a more tight, direct focus on current issues that amount to treason, that are emergencies for our American people, maybe we can more spontaneously prompt the other good people here to feel inspired by our Lord and Savior to begin participating in the verbal exchange here a little bit more. Michael, can you explain a little bit about your emergency page there and how that might all fit together? I yield.
Yeah, they're both very similar documents. Some differences, minor differences, but the same main message. But I just think there needs to be an awakening to the urgency of the hour. It just doesn't seem like it's there. There's something is missing. There is just not an understanding as to what's coming, because if there was, there would be much more action. And
if I may,
that's all I have to say.
I'll just throw in that looking at the people that we do have on the line here, I think Nikki Hanovig is, we've got some really strong hitters here and people who are very active and decades of experience who are on the line. And I feel like we're in, just to let Mike know in Florida, that we have good people sitting here. They're listening. Maybe nothing's new. Maybe, but they are they're putting a lot in writing. I can tell you that much. And it's out there, and they're doing it, and they've got websites and all kinds of stuff. So be assured we're in good company. I yield.
Thank you. It looks like maybe Janet, if I might.
Okay. Yeah, go ahead.
Janet,
Hi.
do you have something you want to explain there?
I was talking to Nikki a little behind the scenes here, and I said where we are, ours is a little bit more on the gut level, and although it is probably what we would call lawful, it's not filled with legal. And I wondered if you would you be interested to show this piece of paper? This is what our people hand out to whoever is violating us at the time. If it's Walmart, if it's our premier, if it's an MLA, like a member of parliament, we have mass mailed these letters, and they're all understandable by the people. So they feel very comfortable. They put their name, one name. I said, you don't have to identify yourself. Just put your county and your name and put it in their hand, mail it to them. And what we're doing is like mass mailing. So mostly I'm trying to listen to what you folks are doing. We have our own little ways of doing things which may not be helpful to you. Our size is like 770,000 people compared to you folks. Like, you're massive. But I'm saying the regular people, if you want to leverage that power, they have to understand what you're asking them to do. And like you were saying, and I'm not criticizing, I'm nobody to say anything. I was a nurse. I'm not anything to do with the law, except that I had to follow the law, doing what I was doing. But a lot of people they can't endorse something like that if they don't understand it. But this, it says, I don't know if you can show it, if you can show it on, it's very simple. It's just when the government and its agents, they become lawless, we the people have the responsibility to restore law and order. Under the laws of the land, do no harm. So that's all we said. And we said there's no law to mask. And under the laws of the land, do no harm, whether it's a hoax or a prank. You can't be putting this mandatory masking on us. And we the people, we require all these measures and activities to be stopped immediately. They're considered trespasses and acts of treason on your part, and you will be identified and held personally responsible for harm against we the people. The right to defend ourselves, I go on and on, against your acts of aggression and tyranny under the laws of the land, do no harm. That's all we do, and we mass. We're going through a campaign right now, whether it's, we say circle somebody's name or add a name, put it in their hand, get it in a mailbox, and thousands of these are going out across the area. And people are throwing them out, but you know what? How annoying it is, they keep getting them. And that is the point. It doesn't really matter who we are. It matters, like, they keep getting them. And eventually, one or two people read it and they go, oh, that's stupid. But when they're getting thousands of them, it puts a little bug in them, and it really is annoying them. And maybe that's all we can do right now, because we don't even have a court. But the people, this is the leverage that we have. And I yield.
If I may.
Michael, I think you had the floor next. Go ahead.
Yeah, we have two different situations. Canada is quite different from the United States, not only in character, nature, but the size, as she pointed out clearly. I think mixing the two efforts on the call is not advantageous. I think for them to, as she stated, listen in and glean what they can is good, but we have two different scenarios here. We have two different problems, and I think the one common denominator that we both can use and will need is the fact that we need people to support us and to be with us and to join us. That is the one common denominator that we have. The rest of the enigma, the parts are different. The solutions are different. And we just can't harmonize with strategy because of those factors. I think the differences between Canada and the United States is too great, and there is not any similarities in the solution and remedy except for we need people to join us. I yield.
Hi, this is David.
David.
I'm sorry, Mike, but I disagree. I was just before you came in there, I was going to ask if maybe Janet wouldn't mind sending an email attachment or something to Charles so that he can distribute that, because I thought I might be able to use some of that, and it sounds simple. When I'm writing 300 pages of stuff that nobody reads, something as simple as what Janet has to offer there as a one-pager could probably help me out quite a bit. And so I think that I won't use the word hypocritical, but I'll use the word conflicting statements to say on one hand that that we need to get people, and then on the other hand to exclude people who are right here in front of us that are contributing a lot. I yield.
Thank you, David.
If I may,
I think I heard a lady's voice there, Michael.
I yield. Go ahead.
This is Nikki, Pennsylvania. And Charles, when Janet was talking a little while ago, I had brought to your attention through the chat, which you can show if you'd like, is the Articles of Confederation in 1778. And in there it mentions Canada coming on board with the United States. And at that time, it was right under after the Declaration of Independence, before the 1787 Con was penned for the nobility. So just to let her know that there is a platform upon which this all can be done. Okay? And with that, I yield.
Thank you.
If I may, I'd
Michael?
like to respond. Yeah, I'd like to respond to David. David, with all due respect, I mean, that's exactly what I said, was we have one common denominator, and that is, we both need to get people involved. That aspect of what she was talking about, I agreed with. The fact that we both need to figure out how to get people involved. We can work together in that one particular problem of this enigma. But when it comes to the intricacies of the law and the character and nature of our problem, they are totally two different. And we definitely can work together when it comes to people and numbers and strategy on marketing. That's a unity there, no doubt about it. I think maybe you misunderstood what I said. I yield.
Oh, most definitely. Thank you for the clarification. Nikki, you're looking great. I yield.
Flattery will get you nowhere, David. Thank you.
Thank you both. If I might, I'm inclined to think that David Scheid's comments about we don't have many people participating, and that's just one side of it. I think that has merit, and Michael's concern for the significance of the difference between the environments in the USA and Canada. There are some significant differences, no doubt. But if I might engage on the specific point that Michael's raising here, the remedies that the people in the States are looking for as compared to the remedies that the people in Canada are looking for. both of our nations are suffering under Roman Empire model tyranny and despotism. Both of our nations have traditions of common law, which is where our remedy's at, and specifically to engage on the issue that Janet was raising of sending out a quick one-page letter to people that are in positions of public servants and are causing us difficulties. I think that is looking to me like a powerful tool in the toolbox. I'm sure the wording between the USA and Canada would want to be different, but the general idea of composing a single-page document to distribute to our people, to encourage them to confront their local corrupted governmental officials, I think that is a similar strategy that would apply both equally well in Canada and the USA, with just a little bit of tweaking to whatever the document is. And there under that gets to and similar a focus on that document that Janet was presenting. I was thinking, aside from obvious differences with a little bit of tweaking in the wording probably, the one big thing that I would say to improve that document would be to explore provisions for what Janet referred to as not letting the people, the corrupted government officials that you're sending the letter to, not letting them know exactly who you are. There is a lot of concerns for anonymity, if I'm saying that correctly, and still getting your rights respected. And that's part of what I think Janet was raising when she said that you can just sign your name and your province or maybe your county or whatever you're in there and leave the details ambiguous. See, that is an issue that I think can be improved upon, because we could affirm qualified elector status for specific individuals, and at the same time we could just assign them a number, a code, and they can use that code when they're confronting the de factos, and the de factos and others would not know who the person really was, but we would, because we got the index of everybody that's registered in our registry of qualified electors. And so what Janet's talking about here, the general idea of sending a single-page letter to the corrupted public servants, with a little bit of tweaking for the states, the general issue of refining that document and building on whether or not the signatures is just going to be totally ambiguous, or if we're going to have some solid identification through a common law qualified elector identification code. See, I'm already thinking in terms of how that might be improved on and applied equally in both Canada and the USA, and they're under that the specific discussion on that particular point is benefiting from the commonality between Canada and the states. And I think it's basically a misconception that there's that much difference between the states and Canada, Michael. And I would respect, maybe I'm wrong, but I would respectfully suggest that especially we're only a small group here with 10, and Janet's obviously contributing. I think it's healthy to take a little bit of time to talk with the Canadian people about similar issues. That's just my opinion. Maybe I'm wrong. I yield.
Well, if I may, the similar issue is consensus building. We have that in common. We need to both build a consensus among the people. We both need to provide a due process to achieve the consensus that we want to present. Those are two common facts about strategy that both nations have in common. That's undeniable.
Yes.
But I think it's a very general thing to want to speak collectively as a people to those who rule over you, whether it be, a democratic republic, a democracy, or whatever you have. It is in the interests of the people to have their voice heard. And to achieve that, they must, in some manner, a systematic manner of process, achieve a consensus of the voice of the people. So, we definitely have that in common. So we can talk about how that is to be achieved. But when you look at the intricacies of the two different domains, Canada and the United States, we are light years apart in character and nature of the two domains. But we both have something in common. We need consensus, and it needs to be heard. I yield.
Thank you, Michael. I can't help but think that it might be of benefit to build on Nikki's comments a little bit with others that have been involved in, I think, both the Beacon 37 Republic group and the National Assembly group. I think they've both got originalist views that, like Nikki was saying, that Canada is welcome to merge with the United States of America. I'd be particularly enthused if Darrell Link might jump in, or maybe Lewis from that are familiar with the Beacon 37 Republic group, that I do believe, if I recall correctly, that they have specific strategy based upon their own research that, like Nikki was saying, that Canada can be invited to join with the American states. Is Darrell or Lewis or maybe Nikki, would any of you like to speak to those issues? Are you?
This is Lewis of Michigan. And yes, Nikki was right. As she's mentioned, and Nikki, I think you can speak further to that, if you will. The thing with the Beacon 37 Republic group is that they wanted to have a certain number, as you've mentioned earlier on this call, Charles, of states on board acting as a Congress, and then look to bring forth the Canadian provinces and the Indian nations as well. So their, I guess, first step, though, as you mentioned earlier, was to hit a particular number of states before reaching out to those other entities. I yield for any additional comment by either Darrell or Nikki.
I yield to Janet.
Oh, thank you. I just wanted to be clear. I have no authority to do that, although it's a lovely idea. I used to have a home in Florida, and I used to come down there for 6 months of the year. And now, right now, with everything the way it's going, I don't do that anymore. But my fellow countrymen, as you know, there's a whole plethora of different feelings. Alberta, I feel there is one movement there that I think they would love very much to become part of the United States, but they have millions of people there. Our group, we're right sitting on top of Maine there. We see ourselves as the Maritimes, and if anywhere we would probably go is the Maritimes within ourselves. But I mean, that isn't really part of the idea. I just wanted to address what Michael was saying is I feel this is not a political statement. This is not a legal document. It is a human problem. And that is what we have in common. We all have a moral compass. We know what's wrong, and we know what's right. And this is saying, you guys are doing the wrong thing, and we see you. It isn't about us and our name and all of that. It is our power as a group, as a volume. They said in Canada we have one politician for every 100,000 people. So if we get people saying we don't like what you're doing, I think that's the power of this. It is nothing to do with, it's a human, I'm saying the mask, they're making us put a mask, whatever is the situation, the vaccination, whatever. That is a human, it is triggering the fear of our people. And as you say, everything else we already understand behind the law. They have no right to do this. It's the gut reaction of the people saying, stop it. We see you. We see what you're doing, and we're not having it. And I guess that's maybe, I had to come to that conclusion myself because I'm a pretty quiet person. But I'm there, and we have 300 people doing this and their families. So I'm hoping we're going to have thousands of letters. We're going to keep going at this. We're going to just keep going at it, even if they trickle in. But it's a human problem. It's not American. It's not Canadian. This could be applied to any country, I feel, because it's what we're trying to deal with the fear, and we don't know what's going to happen. But we're saying we're not having it, and that feels good for a lot of us. It feels very good to have something to do about this problem. Thank you. I yield.
Thank you, Janet. Anybody else? Comments, questions?
This is Nikki in Pennsylvania, and Janet, what you're saying goes right along with the 1776 Declaration, and in there, the first paragraph, which is rarely quoted anymore, is giving that permission. When in the course of human events it becomes necessary for one people, and we are a commonly bound people, okay, to number one, and number one should have been put in there, to dissolve the political bands which connected us to another, and number two, to assume amongst the powers of the earth a separate and equal station to which the laws of nature and nature's God entitle us. And of course we know that the body will build up its own antibodies if it's allowed to, you know. So there you go, and right there with the trespass. And then the third part of that is decent respect for the opinions of mankind, that they should declare the causes, number three, declare the causes which impel us to that separation. 1, 2, 3, the problems of past governments were put in print, or not print, but in penned into that first paragraph of the Declaration, and the problems of past governments and their solutions was put right in there. In the 1700s, it was the Whigs and the Tories, as you know. And in the first century, it was the Pharisees and the Sadducees. And each one, including today with the Democrats and Republicans here, and I don't know what your political parties are up there. However, what it boils down to is the money changers. All for the money changers is what they're doing it for, that paycheck. So thank you for bringing that forward. I yield.
Thank you, Nikki. Other comments, questions? Cliff?
Yes. After listening to everybody's view, I believe if we get together and fix it where you can only do one term, I think that would break up the money changers, because these people are in there for 2 terms, 3 terms, 4 terms, and all they've done is turned that into an enterprise. And I think we can do something about that if we just pass the law, 1 term and 1 only. And I yield.
Thank you, Cliff. Is there others have comments or questions?
I agree with Cliff. This is David. I don't mean to pick on any party or anything like that, but if you just look at what's going on with Biden and his son, it kind of puts it in perspective of this 1 term, 2 term, 3 term, and then how about 1 generation, 2 generations, 3 generations? That these people are turning into families, you know, even the Kennedys and whatnot. That these are families of politicians that are making their money and their riches on politics. Period. I yield.
If I may, let's not forget the Bushes. They're equal corrupt.
And to add to that, it says right there, using the contemporaneous exposition of the wording used in that preamble to the Constitution in 1787, based on the 1785 dictionary, it is we the people. It's not we, comma, the people. It's we the people, someone's private trust maybe, of the united nobility, states meant nobility at the time, of America, in order to form a more perfect union for ourselves and our posterity. And you look at the definition for esquire in 1785, and they are the younger sons of noblemen forever. So, yeah, right there. I mean, they put it in the preamble what they were going to do, and they did it. And they did it legally because of the political bans they put on the people, especially after the 13th Amendment, which allows for voluntary servitude when read properly. There shall be no involuntary servitude, comma, except as duly convicted of a crime within the united nobility or any place subject to their jurisdiction. And Congress, who are Congress? It was the Whigs and the Tories in the 1700s. Today it's the Democrats and Republicans. Shall enforce this by appropriate legislation. Who paused the meeting? Too much? Sorry.
No, it's not that I didn't pause the meeting. That's the screen sharing. That's it, not the meeting. It's about 5 after, and Charles may want to make a concluding statement for the first part, and then you can pick right up.
I'm done.
Thank you. I guess we're at the 2-hour mark then, Louis. Is that correct?
We are, Charles, and so I'm just going to stop the screen sharing. We're going to leave the recording going. I will need to take my leave of the call. I've got a situation that is requiring my attention, and I will make sure to listen to the recording prior to next week.
Excellent.
So, very good call.
Thank you. Bye. And this is the conclusion of our formal business meeting then. I think we can pretty seamlessly carry on with our discussions here.
If I may, I just, hopefully Louis is still not off yet, but wanted to thank Louis for facilitating the things that he's been doing here. He's been in the background providing that support, and I think it's just wonderful the way he's been augmenting things at a leadership position. I yield.
Yeah.
Thank you for that, David, and I'm just now exiting, so I held on just to hear your comment. I appreciate those words. Have a good call, everyone.
Bye. All right. I think we were moving forward with an interesting line of discussion there. Michael, did you have more, or anybody else? I think I might be able to pick it up, but I would like to pause in case anybody else has any thoughts. I talk too much. Anybody? Hearing none. I think in a lot of ways what we're focusing on is we're kind of scooting around the potential, the issue where the rubber meets the road is at the qualified electors and the grassroots recruiting process. And as let me adjust my screen here a little bit so I can see our agenda items. Moving on to agenda item 8. No, that's the Electoral College economic issues. Well, that's going on down to 10. Our qualified electors, everything comes in through into the communities in building responsibly self-governing communities. The ticket in to a responsibly self-governing community is having your qualified elector status go unchallenged and be confirmed. It's nice to have it certified. At some point in the near future, I think we should be issuing identification documents for the qualified electors. And I remember part of what we were talking about. The issues. Cliff raised the issue of term limits. Okay, term limits. And see, there's numerous significant issues like term limits that are frequently advocated by people that have some degree of scholarship in these areas, and term limits are one of the proposed solutions to the evils that presently oppress us. They're under the term limits. I dare suggest when we're contemplating converting to a true common law compliant form of government, like was in existence prior to the Norman conquest of England in 1066 AD, where it was really grassroots, bottom up, like in biblical Torah law in times of Israel. That everybody agreed Moses was the leader, the monarch of the nation of Israel, because Moses could do magic and stuff like that. And so there was consensus. I believe, I can't prove this from Scripture, but when we contemplate the organic nature of those smaller communities, from the 10 household townships up to the 10 township precincts to the 10 precinct counties, at each of these levels, consensus can be maintained by the delegates from each of the lower communities as it's going up the hierarchy. And at that point, you finally get people like Moses or Jesus Christ leading at the top of the hierarchy the entire organic body politic that is fully accountable to the grassroots entry level. And at least for the time being, I better stay with the term limits. When we've got the ability to have instantaneous recall, my little list of important phrases to comprehend, I think it's under what agenda item was that? Where's my glasses? Yeah, scrolling. There they are. Agenda item 5 at the bottom. There's terms of importance in what we're trying to promote here, and immediate recall. It's on the second line. The phrase last from the best. There's 1, 2, 3, 4, 5 phrases. The fourth phrase on the second line there, right before agenda item 6, terms of importance, is immediate recall. This is when we agree that in our community, each of the delegates to the higher level of the assembly has authority of immediate recall, vote of confidence over the leader of that community, then that puts real world empowerment, organic empowerment in the hands of all of the people. And thereunder, when you comprehend this profound empowerment to the delegates to protect the rights of each of their constituencies by jerking the chain, calling for a vote of confidence on the person that's the leader of that larger National Assembly, then at that point, the concept of term limits, with all due respect, Cliff, becomes obsolete. you've got so much real-time accountability that if you don't like the guy that's in the position of leadership, you just call for a vote of confidence on him and get his butt out of there and get somebody else in there that's doing the job right. The concept of term limits is a statutory concept. You're going to reduce things like U.S. senators from 6 years to 2 years or something like that. That would be a big improvement probably, but it's not embracing the more powerful issue that's now on the table, which is immediate recall from the delegates that constitute the jurisdiction that the troublesome leader is in control of. So I wanted to respond to that we're on to some game-changing dynamics here that is totally rearranging the theater of conflict against the agents of the evil empire. So I hope that makes sense. I should probably yield here for comments or questions, especially from you, Cliff.
Yes, sir. Okay, yes, Charles Cliff. If that's not what you call the best idea, I had said years ago, people would run for office and we're $1 million in debt. And at the end of their term, we're $5 million in debt. Now, I think when they make that kind of error, I think there should be some jail time involved because of the people that you're hurting. And the other thing is, you turn around, you took the liquor, you got a tax for that. You took the lottery tickets, you got a tax for that. Now they taking the marijuana, you got a tax for that. They're selling water, you got a tax for that. You guys didn't have all these things when you first went in office. So now that you've got them, why isn't this money going in the right direction? And I yield.
Thank you, Cliff. Comments, questions, anybody? I'll respond to that to the best of my ability. What's being advocated in the documents that I've been sharing is such an organic process. One of the first things we're doing, as we're doing here, is bringing forth the judicial power to address real-world issues. And so if you've got people that are profiting unjustly from stealing from the treasury of the public office that they hold, or otherwise being irresponsible, the jury can do anything they want that's in the interest of justice. There's Oregon statutes that declare that, and this is a general common law principle that's been embraced in statutes, that a court of law, a court of justice, and the chief judicial officer therein have authority to do anything they want if it's both in the interests of justice and in response to the complaint that's presently sworn to be true before the court. So see, if there's a proper complaint presented before a court of law, aka a court of justice, and that complaint inherently involves, even if they're not named, it inherently involves some public servant that's been entangled in some of the issues raised in the complaint, then at that point, that court and the chief judicial officer therein have authority to issue whatever orders are necessary in order to promote justice in response to the complaint before the court. That opens up the whole forum of the sovereignty. This is why a 100 court also commands basically a 100-man army, because once you've got that authority, you can assemble whatever force is necessary to go ahead and go talk to that corrupted public servant about implementing unlawful liquor taxes and water taxes and everything else, and if necessary, remove him from office, and whatever else might be appropriate. And it's custom tailored in non-aggressive manners, so that we're not looking for fights to pick with people, but we can respond with just the degree of firmness and confrontation as is necessary in order that we can start having that public servant's public office start being used for righteous policy instead of pillaging and plundering our common people. I hope that makes sense to you, Cliff. I yield.
And Charles, if nobody else, Cliff again.
Yeah.
Okay, in order for this group to get a little stronger, I feel like we could start out with like the taking clause. How do you get elected? Well, first of all, how do you go to college, get a degree, you end up getting elected to be the treasurer, and you think taking somebody's house for $8.41 is valid, and you have the audacity to go in front of the Michigan Supreme Court to defend that stupidity. And the group needs to jump on something like that because it's going on in more than one state. And I think that would fix it where we would be communicating with other people in other states and forming our group because we have a common bond. You know, we'd have a common reason without getting loud or excessive. You know, something like that. It takes a couple of incidences to really bring our teams together and you know, take it from there. And I yield.
Thank you, Cliff. That's sounding good. Anybody else? Comment, question?
If I may.
Michael.
Yeah, that's what we've been doing here for a couple years. We've been engaging our county commissioners at the local level, and in the process we get heard, and other people, you know, inquire and ask questions. They ask for email contacts, phone numbers, and before you know it, you've got, you know, a small team of people that are focusing on the same issue. I really believe that we must be involved at our local level. I think we're missing something if we don't. And it's a springboard. We can use it as a way of making known our efforts. And for example, last Tuesday I was at my county commission and I spoke and made a declaration that in our local town halls and assembly meetings that we've been having over the past 6 months, it has come to our attention that several of the citizens are wanting a militia. And I made that known publicly. And I demanded an answer as to their response if that were to take place, if a militia, a county militia would be formed. So I'm waiting for their answer. And afterwards, believe it or not, one of the commissioners, one of the prominent commissioners, asked to speak to myself and my fiancée out in the hall, and he made it known that he would join that militia. So that was quite a pronouncement. It was a private pronouncement, and I'm keeping his name confidential, but I believe that eventually he would probably go public with that. And that's what it's going to take. We're going to need to engage the existing de facto, many of which are ignorantly so, I believe. I don't think they all know what they're doing. I think most of them are ignorant. They lack understanding. They lack knowledge as to the criminality of their position. So I yield. Thank you.
Thank you, Michael. Yeah, that's a splendid example of how persistence in local community meetings can work to produce good results, Michael. That's good testimony there.
Yeah, if I may, we cannot assume ever that all of these people are evil and that they are conspiring against us. That the acquiescence fabricates or facilitates the tyranny, but I think most of them do it out of ignorance. They just lack the proper knowledge to define what they're actually doing and what has been done before them. I yield.
Yeah. Thank you. I feel that we're onto some good issues here, but I've had an agreement with Nikki that we should address an issue that Nikki has raised, building off of, I believe, Michael, your concern about the abortion issue. If I might shift gears a little bit here, I see, well, Nikki's gone. I was looking at Nancy. Okay. That ain't going to work. I was thinking Nancy was Nikki. Abort that. Bad idea. And Nancy and Rich and neither one of them have been talking much here. Would either of you care to jump in and let us know what you're thinking? Anything? I yield.
Rich, California.
Yeah.
Hi. Well, I need to send you an email because the first invite that I got on the email I sent you, I wasn't able to get on to the free conference call. So I haven't been able to see these documents. So I haven't felt like I should say much. So I'll send you a new email, and hopefully there'll be a link. I assume you're sending stuff out weekly and out invites weekly. Is that correct?
Yeah. And if have you received the email invitation? Okay, or no?
The first one, none others.
Okay, but you haven't received it for at least a few weeks here.
Oh yeah, at least a month, but or longer. But that's all right because I've called in. But I can see that I really need to see these documents. All right, but let me. That's filler, really no substance. I'd like to add on to the term limits. Of course, not my goal to fix the de facto system, but it would be true in our original form as well. I have protested and written endless letters over the years to. Of no avail, but even to other people, I mean, no one seems to feel that it's valid, but I object to this business of negotiating between representatives of the people on support of bills. Well, I don't support yours, but if you come on and support my taking of this land in my jurisdiction or whatever, that isn't an appropriate response. But the negotiations that go behind us are detrimental to the assemblies which each representatives are responsible for and to. And it also allows, in one state, a corporation may have vital interest, and they're willing to throw money at somebody in another jurisdiction, or in their jurisdiction or another jurisdiction, to get something negotiated to affect the result of voting on an issue in a state, or I mean, it could even be a county or whatever, but I'll just say it at state level, looking at it from the federal portion. So one issue, one vote is what I have been requesting forever, and of course no one likes that idea, but it's transparency. I now know how we felt, how we wanted you to vote. You didn't do it. Now you're beholden. You know, I know where we stand, and you're out. So I have objected to that, and I certainly would like to see that going forward. Let me see, what else? I just so much loved hearing from, was it the lady in Canada? Was it Nikki? I'm sorry, the lady in Canada. I just, for a number of reasons. One, I was wondering if I was, wasted my time over the last 3 years. The oppressors that I see that around me, I do not believe are much different, if different at all, than Canada's, Australia's, England's, France. I don't care where. First it's banking cartels, it's the Crown, it's the Vatican, and the families aligned with the same. So I mean, because we've had legal systems that have come up in a little different manner is pointless to me. We fight the same enemy. And it's even beyond that on a spiritual level. We definitely, in my battle, I fight a general evil against natural rights and God's law. So I welcomed knowing that there's like minds, as well as across the border, and as well as suggestions as to what they're doing and how they, how that could be. It's great. Flyers, great idea. Nothing wrong with that. So very welcome to hear that. I know that the criticism probably level, since this is America-centered, that it could pull things away. But I surely do welcome seeing that elsewhere. Okay, I spoke. Thank you all. I yield.
Thank you, Rich. That was good commentary. Yeah, I had a thought there, but it jumped away from me.
One issue, one vote. That's my point. One issue. Let's vote on one issue at a time. Get on the record and get on with it.
Mm-hmm. That's good. Due process of law does focus on one issue at a time. The process is a course of step-by-step procedures. It's in some constitutions, Oregon's Constitution, due process of law is referred to as due course of law. The phrases are similar. It's a course of step-by-step procedures. Depending on if it's a land trespass case or an assault case, there's different procedures and different courses to follow, depending on what the nature of the complaint is. This is tradition that's reaching back into jury trials for thousands of years, literally. It is well-settled manners of bringing justice and peace to the common community, because if you've got justice, then the people can relax and they can have peace. While there's no justice, you can't have peace. So, and that gets to the issues of how we're organizing at the grassroots level, which is probably the most important issue, the most important area of investing time and energy. And I dare say one thing that would really empower and energize our efforts at recruiting people to be involved is economics. If we pay people, so to speak, that's probably a bad choice of words, but if we economically motivate people to participate as qualified electors, I think that's got a real lot of potential. I can expand on that. Cliff, did you want to say something?
Yes, sir. You gave me another bright idea. I think when a politician gets elected, we should write down how many votes he won by, and society as a whole, they don't keep up with politics. So I would think if somebody passes a bill or comes up with a bill that says, I think we should raise medical bill coverage, and then 1/3 of the people that voted for him should be able to have an emergency vote. And as I use the word emergency vote, put him on notice, we're going to have an emergency vote to throw you out of office, because if you think I need more bills, we didn't elect you for that. And I yield.
That is good, Cliff. I thank you for circling around and talking about your basic concerns from a little bit different angle here. I have fleeting thoughts that escape me, but that are of what I believe is significant value in discussing these issues. And one of the more powerful tools in my toolbox, instead of waiting for a vote, is to bring a criminal complaint against the corrupted public servant. Okay? See, at that point, term limits goes away, and waiting for a vote to oust him goes away, because we've got conflict between Roman municipal law and common law tradition, and common law tradition empowers us to hold public servants to accountability. In fact, lawyers and judges, they posture, they throw words around with reckless negligence, talking about how wonderful is the rule of law. We support the rule of law. And they dance around in their courtroom, monopolies, their railroad station, where they're running a jackbooted Nazi evil empire program, talking about a phrase that comes from common law tradition that grassroots empowers the people to bring criminal complaints directly against corrupted public servants exactly like them. When they're talking about the rule of law, somebody in the room needs to have the well-rehearsed script in their mind about saying, well, seeing as how you're advocating the rule of law, how about under the rule of law, we also adjudicate my criminal complaint against you. And we bring that also before the jury here. And upon proof that in my well set forth and all typed out criminal complaint, a copy right here, throw on the desk, you need to be removed from office immediately with whatever force is necessary, because you're a corrupted devil worshiper, or however you want to phrase it. See, almost nobody thinks in terms of bringing criminal complaints against these corrupted public servants. And I don't want to hear about, oh no, it'll be a big waste of time, because the corrupted courts won't allow us to prosecute the criminal complaints. When we've got a backup to whatever the corrupted courts do, we've got a backup. We can form our own courts. If they fail to adjudicate it by due process of law on the merits, then we move. See, we've got all the chips, all the tools, all the chips on the table, all the tools in the toolbox. We've got everything we need to start re-engineering society in a more righteous manner, right here and now. Comments? Yes, I yield. Anybody?
I do.
Nancy.
Okay. I'm interested in what Cliff was talking about, and it ties in with what you were just talking about. For judges that you know have handed down rulings that are so ridiculous that it is totally against, I mean, you can't even find the laws they're ruling on sometimes. I've sat in courtrooms and written down the laws and the cases they were citing, and then went and looked them up, and they don't exist. So I say we need to start doing what you and Cliff were just talking about, because if someone's sitting in that courtroom taking notes on what they're handing down, and we can undo what they've done, then we need to figure out how to start doing that right now. And maybe we each start with something that we've already been involved in, so that we have access to the documents on both sides. And if anybody wants to help me, I think that's, maybe a good place to start.
Sounds good, Nancy.
May I?
Name and state?
Rich, California.
Yeah, Rich.
Wouldn't that be handled by the jury?
Well, you have to have a complaint first.
No, I'm referring to sure, a complaint and a ruling. But shouldn't the jury be in control of the judge? I mean, the judge's job is not to give a verdict. It's the jury's.
Judges don't give you juries half the time. They just rule.
No, agreed. But in restoring proper government, wouldn't that be handled by the jury? Wouldn't your concern? I'm asking. I'm trying to learn. Wouldn't that be handled by the jury? And I guess I'm addressing that to Charles, not so much to you, but.
Thank you. If I might, Nancy.
Sure.
Yeah, Rich, definitely in my model, the jury will be addressing those issues. My computer just crashed. Are you guys still there?
Yep, we're here.
Yeah.
Okay, well, I don't know why my computer crashed. It's getting a little...
I think we do.
Okay, well, the jury is the ultimate decider. And with regard to the judge, in the model that we're using on the coronavirus complaint is the general model that I advocate. I think it's pure common law that the jury foreman assumes the role of what in municipal civil courts is the role of the judge. He's and the jury gets to have vote of confidence in the jury foreman / judge all the time. And so, if that problem with having a judge interfering with the consensus building process of the jury, that's totally eliminated when we follow the what I believe is more organic, traditional common law process that we're talking about here.
Okay, Charles, Cliff again.
Yeah, Cliff.
You know, I've always thought about that. I've went to jury trials. I guess that's another request we could make, that we have a common law jury, or the court need to hire people that are jurors, and that's the only job they have is to go and listen to cases to make sure the people are getting a proper ruling, because look how many people went to jail, 27 years, and they found out the guy was innocent. Okay, well, I don't think a jury in their right mind would let a judge make a ruling on some bogus evidence, and that would happen. And I think, seriously, we need to bring it up. It may not happen, but we need to bring it up. The state need to pay jurors. You pay for ballot watchers. You pay for everything else. I think some of that good money should go towards permanent jury people. That way they have knowledge in the sense of what we're talking about, and some of the rulings the judges would make, he wouldn't make it in front of certain juries because they know. And I yield.
Thank you, Cliff. I see a lot of potential in what you're saying. If the general system that I visualize gets empowerment, if and when, we'll also have control of the economy. I'm not fond of full-time sitting jurors. The jury should be drawn for differently in response to specific individual cases. But if our jurors are being reasonably economically compensated for their donations of their time and energy in producing the precious resource of justice for our common communities, then that will do very much to empower us moving forward with this general agenda. No doubt. It's a very good suggestion.
Yeah, well, that's what I'm stating. The power's got to stop, or the miscarriage of justice has got to stop. And I'm talking about jurors, like 100 jurors, and they would have to switch floors every week. You know, you're on the first floor this week, second floor the second week, third floor the third week. So the judge wouldn't get familiar with you. You know what I'm saying? It would be, I've seen these folks before, but I don't think I can approach them like that because they may get rid of me. So something like that needs to be proposed. And everything I'm bringing up, I'm not going to say it's going to happen, but I think it needs to happen along with some of the things that may not happen so that at least they see we're involved. You know, we got our eyes on them, and I yield.
Excuse me. It seems like your focus there is in continuing with the present de facto courts, different jurors moving to different floors or something, so the judge can't control them. That's only a municipal judicial problem. If a real powerful word related to jurisdiction is venue, if you've heard that word before, and see when we decentralize the judicial power, see what you were talking about there is in probably big counties where everybody's jumbled together in a big population jurisdiction where everybody's treated like cattle. In fact, they call a lot of their court cases cattle calls when they do traffic issues and stuff. That's how they talk about the people that are supposed to be superior. The judicial officers and the bailiffs and stuff refer to the people that are being drug in there as cattle, and they call them cattle calls. But when it's done right, down at the level of the 100 court at the precincts, there's no necessity for that kind of environment is so decentralized that frequently most problems in a small community of 100 qualified electors, maybe up to 1,000 normal people, men, women, and children, that's a normal precinct level jurisdiction, that most of the time, most of the judicial decision makings would be settled before even going to a full-blown trial. Usually a judge that's the justice of the peace of the judicial office, he can pretty much explain how the law works and how it's going to be explained to the jury, and at that point, the individual person in the in the dispute before the 100 court, the court of justice, court of law for the precinct, will probably recognize that he's facing a losing battle, and he'll just concede without even the necessity of drawing the jury. So everything will be much more smooth and much less confrontational when we convert to a common law society, a common law jurisdiction. And I would only encourage you, Cliff, to try to quit thinking so much about just, I call it rearranging the chairs on the Titanic, which is just trying to make the civil municipal court system run better and more fairly. Yeah, you can do that if you want to invest lots of time and energy in it, but with about equal amounts of time and energy, you can change the whole system. So there's no problems at all like that. So that's all I would try to point out to you. At that point, I yield. Anybody?
Okay, I was trying to let somebody else say something, but I guess they're getting bashful. So I'll try one more thing. Now, I didn't say, Charles, that everything would work, but the groups have got to get some experience under their belt by complaining. So, the complaint department and the unity of our groups need to be known that we will check you. You know what I'm saying? We do exist, and I guess that's pretty much what I'm saying. We do exist because they don't think we do. And the numbers, once people downtown see you guys are here, they've got to join us because we're making common sense based on common law, and I yield.
Great words. Great words. Thank you, Cliff. In my conversations with Michael in Florida before, we've talked about the enforcement issue, and what you just said is I didn't probably use words as nicely as you did on that issue when I was talking with Michael about it previously. In that when we have the only reasonable argument in front of the group, then issues like enforcement are they're going to be uncontested, basically, because nobody else is making any sense in the group. Right, Cliff?
Yes, but that comes with us bonding. You know, me and you. I didn't know you at first. Now, hey, my number one guy is Charles. So you got to do some bonding. I got to see what you like doing. You got to see what I like doing. You know, we may go as far as the 50-yard line, and then we may go to the other end to the 5-yard line. So it's a thing about the bonding of the groups. We need to see these groups get more people. They'll get more people if they hear there's more people. And I yield.
Thank you, Cliff. If I might expand on that just a little bit, it gets down to trust. Okay, you're talking about bonding. This is people bound together in a community that is working to make the country and the local communities a better place. And after people get to know each other pretty good, they can kind of develop a gut instinct about whether or not this person is really trustworthy. And if you go into the law libraries, there are encyclopedia sets, volumes written on the law of trust. Okay? Trust is a big issue, and it includes fiduciary responsibilities and things like this. Fidelity is related to the word fiduciary, and bona fide good faith interpretations of law and statutes and the facts in the dispute, in the complaint before the court. So so much empowerment is right there. It's all mapped out. The laws of trust. You read trust law. It talks about beautiful principles about when people are in a position of trust, like public servants. All public servants, even municipal public servants, have positions of public trust. And when they violate that public trust, and especially if it's a crime, you can bring a criminal complaint against it. And even if it's not a crime, you can still bring a complaint against them to have them removed from office. But, yes. So what we're talking about here, this is the qualified elector building process. This is based upon trust. When we all work together and we start affirming each other's qualified elector status, that's me certifying that you guys are qualified electors, and hopefully you guys will certify that I'm a qualified elector. And see, at that point, we're points of light. We are taking nothing. We've got nothing right now in most legal significance because we're disenfranchised. But when I certify your trustworthiness and your qualified elector status, that's kind of a sacrifice on my part. I'm doing it for you. And when you get two of those, that's prima facie evidence that you are a qualified elector. Okay? At that point, if you chase it on up the hierarchy, you could be the one that's deciding who's going to be the next president of the United States. That's a digression. The point is that qualified elector status empowers you to be head and shoulders above the vast majority of the people that are out here fighting for scraps, the 14th Amendment slaves, and when we start doing this for each other, we're building the trust, we're building the bonds, like what you're talking about. We're establishing our self-governing communities. And the de factos, the prosecuting attorneys, the cops are pretty much stupid, most of them. But some of them you can communicate about these issues with. But lawyers and judges especially, they kind of pride themselves in a perverse way on their ability to intellectually engage in intellectual swordplay. And you start pulling out this sword, talking about common law communities of townships and precincts and constables and justices of the peace, they run and hide. They're cowards and they're bullies. And all you need to do is have a few of these concepts firmly in your mind, and you can run them up a tree. Anyway, yeah, good ideas, Cliff. I should probably yield here for a moment. I yield. Anybody? Hearing none. There is something else in the back of my mind. I see Nikki came back in and joined with us. Nikki, I'm wondering if you're thinking this might be a good opportunity for us to discuss the current email exchange that we've been sharing back and forth. Are you there, Nikki?
Yeah, I'm here. I had a phone call I had to take, but in just a moment, I've got to shut up a light over here.
Okay, we can postpone for a while longer if you're not ready yet.
Okay. Sure. Yeah, I don't know really, what that's all about, what you guys were trying to get at with me. But I'll let you go ahead and, present whatever it is that you want to present.
Okay, well, we had kind of one. Thank you, Nikki. Great to see you. We had one issue lead to another, kind of. I think we started out talking about abortion, and you were making suggestions about how to address the abortion issue. I think you were. It seemed to me I kind of boiled down some long text there. It seemed like you, on the abortion issue, you were focusing on the body parts that are being sold for profit by the medical professional perverts, and I think you did a lot of text there, and I kind of boiled it down to just summarizing that. Okay, so you're concerned about the profits for the issue that is being made there, and I think you were also implying that the best argument to make to women that are considering abortions like that, or that have had them, I think you were proposing that that we approach those women and inform them about that commercial process, profiting, and that we try to use that as either a recruiting mechanism into our group or a strategy for getting them angry at the corruption of the system. Am I summarizing there pretty correctly there, Nikki?
Yes, you are face to face. Yes, on paper it wasn't coming, or not paper, but on the email it was not coming across like that.
Yeah.
But yes, because of the way Roe versus Wade, I mean, you can just go through Roe versus Wade, anybody can, and just pull up or do a search for the word potential. And you'll see the potentiality for this, the potentiality for that, and it all has to do with state. They're adjudicating on behalf of the state to be able to legalize abortion in that state. that prior to that was against abortion totally. And the thing is there is a lot of women that I have spoken to in the past that would not have had an abortion had it not been for the fact that the government allowed for it. And they were very sorry afterward.
Mm-hmm. Mm-hmm.
So, you know, to me, a great strategy would be to just put it out there is that, you know, they were profiting from the sale of your body parts. They owe you for the production of that particular commodity. So, you know, that would be a way to get people who, oh, you can't do anything about government and this, that, and the other thing, you know. So it would give them an anger to get off their butts and say something is what it was all about. I don't know how you guys misconstrued it that it's my, you know, abortion issue. It's not. It's an issue that really needs to be addressed because it has been done so many different times in so many different ways to us, even with the driver's license. All driver's licenses are commercial with restrictions, and the Department of Transportation is the process agent for the United States Corporation Company in all 50 states. So this is entrapment into things that we would not ordinarily do to enter into adhesive and unconscionable contracts if we knew the truth behind these contracts. And abortion was just one of them, Roe versus Wade. That's all I was getting at. And to me, I mean, I didn't violate any of the commandments. I mean, you know, as far as the body politic goes that we're trying to address here. So
yeah. And I want to say I'm sorry that my end of the conversation went in that direction. I didn't mean to imply that you're violating anything. I was just having trouble comprehending how your argument there might be used constructively. And I think you've got a vast repository of knowledge and experience here, and no doubt the commercial issues are important, and I don't want to downgrade that in any way, but so frequently this is why I prefer discussion like what we're doing now, is because we can cut through any dysfunctionalities that might be coming up, and we can read the essence of what the other person's trying to say, and just kind of react from the gut there instead of just what the dry text says, you know.
And Charles, if I were anybody else except me, because, you know, and there's a few people like me, I'm sure, but I've actually had training as a mediator, so I recognize, you know, that if people have their positions, and if they don't focus on their common interest, nothing is ever going to be resolved. However, focusing on the common interest rather than, oh, I have this position and I have this position, and you must mean this because this is the way my mind thinks, or you must mean that. No, until people get together and actually discuss their common interest, and the common interest is for the people and to recognize how they're being entrapped into unconscionable and adhesive contracts, and they're not reaping the rewards of it based on what we were told we had as a government. It's all based on fraud when it comes right down to it, or it has been taken over by kind of a mafia-style, you know, enterprise, criminal enterprise at that. Yeah. Especially since 1913. And, I mean, you know, the history is there to show what happened, how it happened, and who was responsible.
Mm-hmm. Mm-hmm. Yeah, you're sounding good, Nikki, is almost always you do in direct conversation. I don't know why we seem to have problems in email communications sometimes. But can you hear me okay?
Yes, I can hear you.
All right. Yeah, would anybody else care to comment on this issue of yeah, I guess abortion is just a technical aspect of the general manner in which you're talking about promoting remedies here, right, Nikki?
Correct. Uh-huh.
All right. I know that abortion issue is quite important to Michael. I don't know if you might be inclined to comment at all, Michael, there. Or we can move on to more general issues. I see Dave and the Thumb joined with us. Yeah, welcome, Dave.
Howdy.
I think there was more to Nancy's issue, but I think we resolved the vast majority of it just right there in that simple little discussion. I think we've covered quite a bit here today. Is there anybody else that has anything else that they would like to talk about? Go ahead.
Do have one more question.
Sure, Nancy.
I've been going over your documents. Excuse me. And I'm newer to the private side of stuff than the public, you know, with court documents and stuff like that. I was looking for a sort of, it's called a prayer for relief. You're asking or you're telling the judge or whoever you're complaining about what you want, what based on, the real law, what you're expecting to see. And it usually comes near the end of the document with sort of a brief reference to the laws that you presented to them that they're violating. And because your documents are a little bit different, I'm trying to figure out where, because I don't see that. I mean, we want them to fix what they've done. We want them to clean up the mess, and we want them to rule according to the real law, not their personal opinion and whatever else they got paid to do. So maybe I just missed it. And there was one, hold on, I'm trying to see if I can pull it up. What the name of the document was, but at the top it says United States of America, just notice of this complaint, and then it's got treason.
Yeah, the constructive notice of treason document.
Right.
Yeah.
They are doing that. That's for real. But
you're breaking up real bad, Nancy. I can barely hear you, Nancy.
What are you demanding that they do? Demand they do something. And I want to go with ask. Kind of
you're breaking up real bad, Nancy. I can barely hear you, Nancy.
Hold on a second.
Yeah.
Is that better?
It seems better, yes.
Okay. What's the demand? What's the resolution? What's the remedy that you're asking for?
These documents aren't demands. They're not seeking a remedy. They're laying preliminary groundwork for producing the remedy. They're foundational documents upon which a criminal complaint against one or more public servants can be brought.
Okay.
Does that make sense to you?
Yeah, that does make more sense. That means that the other documents, none of the documents are standalone. They have to go together, right?
I'm not sure, but that's pretty close to true. I know, close enough for now.
Okay, yeah, this is just different than what I'm used to seeing, so I'm just trying to go with your flow.
Uh-huh. Yeah.
Okay.
Well, specifically, you've become at least somewhat familiar with our coronavirus complaint, the militarism that's coming at us here. And correct me if I'm wrong, but I think you volunteered to be one of the jurors that'll adjudicate that, right?
Yes, and I did send a document. My email got hijacked. I couldn't get into it, and then when I could get into it, I couldn't send anything. And I had some documents that I was sending that somehow I can't get it open anymore. So I had to delete it because maybe it got corrupted or something. So I sent you the one, and everything's in it except the notice of it's like a demand. If they're going to arrest me, I'm going to demand money because they injured me. And so the last one that I sent has everything in it but that. And if anybody knows, I cannot open that document anymore. So if anyone already knows the penalty for arrest and all that, just put that in the document because we kind of need that. And if anybody wants to add to it or whatever. Okay. Hello.
I think we might have lost Charles.
Uh-oh. Yeah, I heard a screech, and now, is anybody else on the line?
Yeah, just one person got bumped off.
Okay.
Yeah,
I'm not sure who else is all on the call, but I didn't hear any other chimes that other people left.
Yeah,
there
looks
were
like
6
he's
when I just got on a little bit ago. So now there's 5.
I got knocked off my phone. I'm sorry.
So there's a penalty for arresting you. So if anybody knows that penalty or remembers it, I can't open that document anymore. So if you want to add that, and if you want to add something else or delete it or whatever, yeah, I just wanted to get something, because normally when I go in the store, I don't wear a mask. So then they say something, I ask them for the law or something, and the other day they demanded a document. Well, I didn't have one with me because I haven't been asked for one yet, so now I want one.
If I may, they demanded what kind of document? From your doctor or something?
Yeah, a medical release.
That's illegal.
To be released,
are you in America?
Yes.
Yeah, you know about the ADA, right?
American
with Disabilities
Act.
Yeah.
Oh, yeah.
Yeah.
I didn't go that route because in this area, it's a big Muslim area, so they're used to the religious thing. But I see exactly what you're saying, so that's a good thing. All right, I will add something on that. So if anybody wants to add something that we might need, jump all over it.
So yeah, there's also a notice of liability that there is a $75,000 fine for the first offense if they ask you to wear a mask, and a
I didn't know that one either.
$150,000 fine for the second offense.
Can you put that on there and mail it, so everybody else can have it too? Because that's a good one. Anytime you're talking money, the court backs off.
It's actually a federal felony for anyone to ask you to wear a mask, according to the ADA.
Also HIPAA.
I didn't know that.
And right, and with the HIPAA law, it's another felony if they ask you to produce a document that tells them what your disability is.
I didn't know that either.
Yeah.
That's a good one.
Yeah, that HIPAA law finally is working.
Awesome.
And there's also a claim of cognizance, which makes it an issue between two courts and not between the plaintiff and the defendants. And I put the link into your into the chat area there.
I can't get to that.
Oh, okay.
I haven't got my computer back running yet. I've only got part of the stuff up there.
I'll give it to Charles.
Oh, yes, I would appreciate that. And everybody that wants to add something on there, because, there's good counsel in many heads. So if we cover all the areas before it comes to be a problem, people will back off quicker. And when people see you doing this, they're going to want to learn.
Yeah. When we start developing real empowerment, other people will want part of that empowerment.
Yes. And they'll want the same protection and rights that we're using. They'll want to learn them. So it's kind of like we're teaching them by them seeing it.
So if I may, I told a buddy of mine, he's a mechanic for the bus depot for the state of Indiana in Indianapolis. And when they, about a month into the COVID thing, he was texting me, telling me he didn't know what he was going to do because he might be losing his job because they were going to start mandating everybody wear a mask at his depot, and he wasn't going to wear one. And I send, I'm part of the Michigan Assembly, and they gave us that notice of liability, and I sent him a copy of it, and he said, where can I get this? And I said, just go to the ADA. And he texted me back, and he said, got it. And he printed 25 copies, and he went to work, and he handed, the day that they were mandating everybody had to wear a mask, he handed a copy to his human resources manager, and he said that manager dropped his head, he mumbled something, he turned around in defeat, and he walked away. And I just talked to him a couple of days ago, and he's still not wearing a mask. He said nobody's wearing a mask in his department back where the mechanics are working on the buses. It's under 9 acres, but he said nobody's wearing a mask, and except the people that want to wear one, but for the majority of them, nobody's wearing a mask.
Good. Are we
so
going
that's a state agency, and I think it's a pretty powerful, that ADA. So I don't think you need much more than that.
Are we going to exchange email addresses?
I'm good with that. Nancy, I was going to ask you, I think I dropped my call when you were talking about that you needed some documents from me. I didn't get in my notes what documents you might need from me. Do you remember if you were asking?
No. I was talking about your documents. I'm trying to get familiar with the way you write them because they're different than what I'm used to seeing.
Thank you for noticing that.
Well, that's good too, but it just kind of handicaps me because most of what I learned from being in court by demand, not by choice. And I would watch the judge. I would go early, sit there, watch the judge, because I was trying to figure out where in the world do they come up with the stuff they come up with. Because a lot of what they're doing just is not in any law book anywhere. And that was when I also noticed that attorneys make up citations to cases that don't exist in order to win. So they're basically just lying. And the judge always looks at the end of the document and he'll read the end of the document before he'll read through what you're talking about. So if you don't have a prayer for relief in the document at the end, it's like he blows you off because he doesn't want to bother to read the document.
If I might, that's the nature of municipal jurisdiction. I'd like to point out an underlying factor of organic law in jurisprudence, in that the judicial officers of the municipal government, the de facto courts, are they are empowered to exercise common law jurisdiction, and common law is based on principles. It's not based upon statutory codes or rules.
Right.
Okay? And they're under that judge, when he's got a complaint before him, he can't empower himself to move forward by himself. But if he's got a complaining party before him, he can basically do anything he wants, because statutes and codes are irrelevant, rules of civil procedure are irrelevant, rules of criminal procedure are irrelevant. The only rules that are applicable, if you can articulate them, are common law due process rules. And most people can't articulate them, so most people get railroaded, because the judge usurps all kinds of power, saying this is my courtroom, when it's really the public courtroom, like what Cliff and others have been saying there. Go ahead, I'll yield.
No, you're right. I know what they do. I've seen what they do. And I also know that if you can't hold them accountable, they'll just do what they want. Or they'll do what the attorney says.
Yeah. Name and state?
Yeah, Dave in the thumb of Michigan here. I've got a friend in Kansas, and what he does is he goes and he gets the judge's oath of office, and then he writes on it diagonally from bottom left to upper right across the words, and he says, I, and he states his name, accept your oath of office as a binding contract between you and me, one of the people. And, I can't remember exactly everything else he writes, but he says every time he does that, the judge either recuses himself or, he's had judges stand up and walk off the bench and just walk out of the courtroom and close the door.
Most judges here don't even have an oath of office.
Well, and what state are you in?
Michigan.
Oh,
Wayne
you're in
County,
Michigan too?
Oakland, Macomb, yeah.
Okay.
Close, Cliff.
I do know some folks that they've told me out on the west side of the state that they've done this process and it's working. But I don't know, what does our general our Constitution for Michigan say? Do they have to have an oath of office?
Yeah, they're supposed to. Otherwise, they're simulating the legal process.
Right. So I don't know what the
I've called them on it. I've called them on it. I've given them notice of being in the wrong venue. I've done all kinds of things. The majority of it does not work. They just arrest me.
Wow.
The one court in Novi, I was arrested. The last time I went in there, I was arrested 11 times. The first time was at 8:10 at the window before I even got into the court.
Wow.
Yeah, they don't, and this judge was a senator that was removed from office because of drunk driving offenses. He pled guilty, and now he's a judge.
Oh, isn't that special?
Yeah. So he's not even.
What about the insurance company? Are they bonded?
They did not read the charge into the record, so the prosecutor is not liable. And I didn't find out about that until after. Now, I had 10 tickets in 3 courts. I got 7 tickets disposed. This Novi court, I still got 2 tickets in. I'm sorry, 1 ticket in. So everything, now the one court in Allen Park, they were the one that saw that what I was doing, and they disposed all 3 tickets. The second court is Lincoln Park. I could not even get a court date to set aside the default. And they never notified me of a hearing anyway. They just suspended my license. But I had already gotten a license in another state and rescinded the Michigan license, so they created a new license and put tickets on it.
Wow.
I didn't ask for that license. So they're very creative here, and that's why I know that what they're doing, they don't care. It's you have to hold them accountable for everything, and some of it I just don't have that kind of knowledge for. But I have looked up oaths of offices, and most of the judges here do not have one.
Well, we're going to have to do something about that.
If I might, Dave, that does sound like good strategy. That the accepting the oath and contracting with the judge. I'm not sure it's the best, but it's certainly a nice tool in the toolbox there. And I mentioned this before, my magic bullet for all of that is to bring a criminal complaint against the presiding judicial officer if he's seriously problematic and he don't respect the words that I'm saying to him.
Yes.
And especially with prosecuting attorneys.
Yes.
Attorneys, I do that out of the gate. And when I compose my criminal complaint, like you'll notice in the one that we're doing on the coronavirus issue, I've got 2 courts there. I've got the appropriate de facto municipal court and from de facto government that it normally goes to, and then I've got at least 1 court of common law jurisdiction, like our Supreme Court of Law for the USA here. I'm on our coronavirus thing, I'm naming both the Supreme Court of the USA de facto and our Supreme Court of Law. And I've already composed a case number for our court, and I just left blank for the Supreme Court of the municipal government of the USA. And we'll send them a copy of that, and we'll ask them probably to get a case number assigned, but they might just stonewall us, and if they do, that's okay. We'll take jurisdiction ourselves. So anyway, Nancy referred to earlier about I forget what the situation was she was responding to, but it seemed like a false arrest or something. And she was responding with commercial remedy, finding having some type of a default commercial judgment against the corrupted public servant. And especially when it's in response to a false arrest, I'd like to point out that it's real easy to get entangled in what I refer to as inferior law. If you read the 7th Amendment carefully, it is referring to the rules of the common law as being a superior form of law, because if you get your jury trial verdict, that trumps all of every other court in the USA. All of a sudden starts to have to follow those rules of the common law, which is a system of higher law, and is concerned about a breach of the peace. And technically speaking, all common law is criminal law. It's only concerned about whether or not a breach of the peace has happened. And when a cop does a false arrest or otherwise does anything that interferes with your person or property, it's basically a crime. And see that this whole jurisdiction of civil procedure, that's all legal fiction procedure. That's not real. Civil is municipal. Municipal is Roman Empire. Everything from the Roman Empire is not law. Only common law and natural law and organic law are real law. Roman Empire, civil, municipal statutes and codes, and case law, technically speaking, is not law. Okay, and so we they're under Nancy. You're great if you can get economic resources out of them, but it seems like the economic resources strategy, like Hartford Van Dyke and many good others that I respect, they routinely use that, and it's very difficult to get economic compensation from the de facto courts. And so I dare suggest that it's probably at least equal to bring a criminal complaint against them, which places you solidly in common law jurisdiction. And then when you're stating a criminal complaint in common law jurisdiction, that lays the foundation for an accusation of treason against the corrupted judges and prosecuting attorneys and all of that kind of stuff, especially when coupled with the documents that we've already been discussing here, the constructive notice of treason document. When you got that backing up your criminal complaint against a corrupted public servant, then all of a sudden they realize that it's not just a normal criminal complaint. It's also implying that they are involved in a treasonous conspiracy to reduce our American people to slavery. And see, everything escalates when you start going criminal and you start talking about treason. When you're only talking about commercial stuff, they've got infinite supplies of money, Nancy. They can play that commercial game forever and ever and ever, because they can keep hyperinflating until they pay you off and everybody else and keep it going. That's what they're doing with the Wall Street bankers and everything right now. So I just wanted to outline those thoughts. I yield.
Well, that's a good point. I like that.
Thank you. Thank you. I'm really glad that we're having this conversation, Nancy. It seemed in past conversations we were having difficulties harmonizing, and I was frustrated by that because I can see you're a smart woman, and I couldn't figure out why we weren't communicating effectively. And I'm glad that you're hanging on the later part of the call here, and that we're able to talk these things out. This is good. This is healthy. Thank you.
Oh, well, thank you. Everything's different, and eventually you just kind of, it's like the truth comes out.
Mm-hmm. Yeah, patience is a real virtue, a real virtue. You know, there's a lot of people that at different times they're difficult to work with, and if you just go, well, okay, we'll see what happens next time around, then boom, next time around, all of a sudden it works out a whole lot better.
I'm gonna trust in that. A lot of the stuff is really frustrating for me because my first experience was I sat in jail 10 days for a paid ticket. So this isn't just logic and reason. I want blood, and I want damages. Well, like not physical blood, because they put you in jail for that for real, but there's a kind of blood that they have. It's like they're evil, and I want to snatch their ability to be evil to people away.
Very well said. For the record, that blood reference is probably something that we shouldn't be choosing our words like that very often, and I'm sure you were speaking figuratively, not literally.
Well, yeah.
Yeah. And that's part of my frustration with the many good patriots that pursue the commercial remedy. they've got slush funds that if we do end up finally with a big judgment against a corrupted public servant, they've got their own insurance pool where a multitude of them have all pooled together to cover the few that might get caught. And so it doesn't really come out of any individual's pocket. It comes out of their slush fund that they've got in place to protect against the few patriots that might actually eventually get lucky enough to actually secure a commercial judgment against them. And that's part of why I like going for the criminal complaints. And when you move it, when you present a criminal complaint, that causes everybody that's looking at the case, court clerks, and things like that. When you say, do you realize this is a criminal complaint against that public servant or judicial officer there? I've had them in Clackamas County, Oregon, a court clerk say, no, I didn't realize, and I know. It was right on the face of the paperwork. And then all of a sudden, I'm pointing it out to her. Yeah, see, it says criminal complaint right at the top of the page there. I know I know she's being disingenuous. I know she saw a criminal complaint there at the top. But the point is, she's posturing as though she didn't see it. And the only reason she's posturing as though she didn't see it is because she knows that when she's got a criminal complaint filed in her court, that she's got to treat it different. It's not just normal civil procedure that's designed for the Roman Empire slaves. All of a sudden, there's a game changer. Somebody could go to jail for criminal complaints. And that includes clerks that misapply the paperwork, misfile it, and stuff like that. Go ahead, I yield.
No, that just brought up something. I used to listen to all these Winston Shrout tapes and CDs, and I never appreciated them because I knew he wasn't writing the documents. I could tell by the way the documents were written that he didn't have anything to do with them. So the only thing that I ever got out of any of his work was you have to sue the warrant. Suing the warrant is filing a counter complaint or a criminal complaint.
Okay.
And you just put that together for me.
Well, thank you. Winston Strout's work, there is some talent there, like I believe what you're saying, but I similarly had troubles getting any kind of traction with it, and it was mostly commercials.
Right, he was all over the map.
Pardon me?
Everything he did was all over the map. When he was teaching, he was all over the map. You never knew where he was going, where he came from, or where he was at in the process he was telling you. So the documents that he presented, when he presented them, didn't go with what he was saying. So I finally put it together that he was not writing the documents. But if you take him out of the documents, you can follow the documents. Mm-hmm. But if he's discussing those documents, you can't follow him. You don't know where he's going. So the only thing that I ever got out of those tapes was suing the warrant. Suing the warrant is a criminal complaint, and you just put that together for me, so now I know what to do to finish.
Nice. That is, I hadn't heard the phraseology of suing the warrant previously. I'd be very interested in keeping in closer contact with you on how this idea might be developed.
Well, what you're doing is you're going from being the defendant or the accused to now you're the one bringing the charges against them. And you just showed me how to do that. So I take every document I've done, and all I have to do is retitle them.
Don't
because
you like it
I was coming from the accused point. Mm-hmm. I'm not the accused. I'm the injured party.
Well, I think what you're doing there is you're making a counter complaint, right?
Yes, same thing. That is exactly what suing the warrant is.
Okay.
The counter complaint, the criminal complaint.
Especially when they're coming at you against something like they're claiming that you've done some misdemeanor crime or something. See, it's already on the criminal docket. A lot of trouble we have is getting on the criminal docket, but when they bring a criminal complaint against us for traffic, at that point we can file our answer and criminal counter complaint. Because we're already on the document, we can use the same case number. And,
right.
And at that point, it's going to freak the judge and everybody out because
now
they've got to give you a trial if they want to. Pardon me?
Oh, my gosh. Now, okay, you just answered another question because I was trying to figure out if I needed to start another case, but you're absolutely right. I already have a case. And there's no statute of limitations on fraud.
Right, exactly.
They just defrauded me.
Mm-hmm. And
oh my gosh.
Well, and what really empowers it is if you not only file in the de facto court that you're being drug into, but you also file it in a court of common law jurisdiction, like what we're doing here. And that way, if it starts breaking bad in the de facto court, if they start acting like they're going to railroad you anyway, or it can break all kinds of ways bad. Then at that point, you can back off from trying to put a lot of time and energy in de facto court and just come on over here and we'll whip out a jury verdict for you real quick, because we got lots of patriots that know of the institutionalized evil over there, and it'll be real simple for you to make a case sufficient to get 12 signatures slapped on a document real quick saying you are right and they are wrong, and thereby declaring you innocent and not guilty. And maybe even declaring that the prosecuting attorney and or the judge need to spend 30 days in jail or something like that.
And they have to make me whole by paying me for my time in jail, losing my car, being evicted, losing my job.
Yeah.
Okay.
Especially
this is
if
awesome.
We give them plenty of notice to appear and defend, and right, we can do it in a phone conference like this, and when they don't appear and defend on your counter complaint against them, then the jury has to make their decision based upon the evidence in before the court, and when they aren't even appearing and contesting what you said, well, Nancy must have said it right, let's go ahead and whip it out here.
Okay, this is cool.
Thank you.
Boy, I think this is called skinning the judge.
Kind of like skinning the cat. Well, they're not real judicial officers anyway.
I know, they're bogus.
Yeah, but nice, colorful terminology.
In Michigan and some of the courts, the judges will not even sit on the bench. When they see your paperwork, they go out the back door, walk all the way around, and enter the courtroom the way we have to come in. And then they go up and stand beside the bench, and they can't have their robe on. And then when they go do their next case, they just go up on the bench and they put their robe on.
Mm-hmm.
So that tells you something right there.
Right. I think there are local vacant judicial offices for common law jurisdiction, and if some of us do paperwork up front claiming those vacant judicial offices for county or precinct level judicial office, that when that de facto judge steps down, I think we could present our paperwork to the sheriff's deputy or whoever and go up and just take that judicial chair away from.
Yeah, we're going to have to check that out.
That's a big one right there, because because I know that I've seen them exactly like what you're saying. They frequently step down off the bench. Once we start making real good arguments, they step down. And I think what they're doing is they are surrendering control of the courtroom. And I think we can make arguments that we are our friend. If it's us having a case, we need a friend there to take the judicial office, because a litigant can't be a judge in his own case. But with friends there anyway, we should be able to take control of those courtrooms, because we've got the higher law, common law, judicial authority for that county or precinct. They're by their very nature of their circuit or superior court judge jurisdiction, they're a municipal court of limited jurisdiction, and the court follows the suit of the sovereign. So it's dependent upon the individual bringing it forth, not necessarily the franchise, but the other people are franchisees from the municipal jurisdiction, which means that they are an inferior jurisdiction. And if you can articulate this in front of other judicial officers and court bailiffs and stuff like that, I'm pretty sure that you can run them up a tree.
I'm looking forward to that.
All right. All right. Well,
awesome.
We're down to just 4 people in conference here. It's great discussion, but I think we've kind of covered most of the bases here. Is anybody else got much to talk about? It looks like we lost Rich from California. It's just Dave and Nancy and me here. Dave, Nancy, you got much more that we should be chattering about here, I'm wondering?
No, I'm going to work on some of the stuff that you just told me, and all I got to do is change my documents mostly, and they already have the court case numbers on them. This is going to be awesome.
All right. Well, if I might presume, I'll be glad to review your documents if you can send them to me by email if you feel like doing that.
All right, let me get my whatever's going on with my computer figured out, and then I'll do that.
All right.
Thank you.
Yeah. I'm thinking of bringing the meeting to a close here. Nancy or Dave, do you have any other things to say, or are you?
No.
Good night, all.
All
Good
right.
night.
Thank you both for coming. We'll see you again. Bye now.
Good night.
Good night. And I am Charles Stewart. This is the 17th of October, 2020. And I'm stopping the recording now.